the clock is getting stuck. Just see then. Just remove that clock. Close it.
Hello. A very good evening to the esteemed members of the tribunal, distinguished guests, learned members of the faculty, dear participants, and ladies and gentlemen. Welcome to the grand finale of the 7th MK Nambyar Memorial NUALS International Maritime Law Arbitration Competition, NIMLAC 2026.
What began a little over a month ago with the release of a proposition, a complex maritime casualty aboard the MV Pragya, tangled questions of carrier liability, emergency arbitration, and the consolidation under the SIAC rules, has now, after weeks of research, drafting, and relentless preparation, brought us to this moment.
Teams from across the world registered, submitted memorials, and tested their arguments to the preliminary rounds, the quarterfinals, the semi-finals, and today, two teams, the last ones standing, take the floor for the final time in this competition.
With the tribunal assembled and the advocates at the ready, the grand finale of the 7th MK Nambyar Memorial NUALS International Maritime Law Arbitration Competition may now commence. And we now hand over to our courtroom managers, Ustat and Malavika. We wish both teams the very best. Thank you.
Good afternoon, everyone. My name is Ustat Kaur and I'm here with Malvika Manoj, and we will be the courtroom managers for the final rounds of the 7th MK Nambyar Memorial NUALS International Maritime Law Arbitration Competition. I extend a very warm welcome to the arbitral tribunal present today and the participating teams. It is our honor to introduce the members of the distinguished panel in front of you today, who shall be presiding over the grand finale of NIMLAC 2026. First, we have with us the presiding arbitrator for the proceedings today, Honorable Justice Ishwaran S., currently presiding as a justice at the High Court of Kerala. Sir has over 25 years of experience specializing in areas of banking law, insurance law, and service matters. He was the standing counsel for the Indian Bank and Life Insurance Corporation of India, in addition to being the panel lawyer for State Bank of India, Catholic Syrian Bank, and South Indian Bank. We welcome you, sir.
It is a distinct honor to welcome Advocate Joy Tattal. Enrolled with the High Court of Kerala in 1995, he brings over 3 decades of experience across shipping, taxation, constitutional, company, and civil law, with a strong focus on maritime disputes and arbitration. Widely regarded as a leading maritime practitioner, he serves as the Secretary General of the Indian Institute of Maritime Law, contributing to policy dialogue and industry engagement. He is the founder of Joy Tattal & Co., now involved into Calidus Legal, a full-service law firm with an international presence, where he continues to serve as managing partner, leading complex commercial and maritime matters. We welcome you, sir.
Next on the panel, we have Captain Sushil Shankar, a dual qualified lawyer, arbitrator, mediator, and master mariner, specializing in shipping and commercial disputes. With a strong foundation in both maritime operations and legal practice, he has served in the Merchant Navy, including in command of vessels, before transitioning to dispute resolution and arbitration. A fellow of the leading professional bodies, including Chartered Institute of Arbitrators, London. He is also the chairman of Visakhapatnam chapter of the Company of Master Mariners of India, and is impaneled with the prominent arbitral institutions. We welcome you, sir.
Now, it is our privilege to welcome Advocate Manisha Tiwari, a maritime lawyer, arbitrator, and managing partner of Shell & Partners Co. She brings close to 2 decades of experience in shipping, maritime, and international trade law. Her practice focuses on complex maritime disputes, including ship arrests, cargo claims, marine insurance, and cross-border arbitration and litigation, advising a diverse global clientele. A silver medalist in LLM in maritime law from the Indian Maritime University, she also contributes to academia as a faculty member, teaching core subjects in maritime law and dispute resolution. We welcome you, ma'am.
And last, but certainly not the least, it is a privilege to welcome Mr. Ruchir Goenka. Currently an associate partner at Bose Mitra & Co., Sir is known for his extensive experience in commercial and maritime disputes, including charter party disputes, cargo claims, ship arrests, and enforcements of awards and judgments. His practice also covers maritime casualties, salvage, wreck removal, limitation of liability, and general. He regularly contributes to leading maritime law publications, reflecting his continued engagement within the field. We welcome you, sir. We are grateful to the distinguished arbitrators for their time and for presiding over this session today.
Now, on to the general guidelines for the participating teams. Kindly note that no personal identifiers are to be disclosed at any stage of the proceedings. Teams are reminded that compendiums or any other materials are not to be submitted during the course of the round. The arbitrators have already been provided access to all the relevant materials. During the rounds, communication amongst members of a team, if required, shall be restricted to written notes exchanged within the team, and no verbal communication shall be permitted while the proceedings are underway.
May the panel please note, each side shall be allocated 45 minutes, inclusive of rebuttals and sur-rebuttals. Out of the total time allocated, 2 to 4 minutes shall be reserved for rebuttals and sur-rebuttals respectively. The total duration of the finals shall be 90 minutes. Please also note that during the course of the proceedings, we shall indicate to the teams and to the panel when there are 5 minutes remaining, 3 minutes remaining, 1 minute remaining, and when the time has elapsed.
The teams are now requested to discuss and deliberate and reach a consensus on the format of the proceedings today. Judges, please note the following format.
Is there any suggestion with respect to the procedure that the respondents would want to suggest?
I think we would like to go ahead with the standard. Am I audible? Okay. So I think we would like to go with the standard procedure for arbitration, that is the format of RCCR, if you agree with it.
Yeah, we agree with it. So the respondents go first, followed by the claimants for the procedural issues.
Yeah.
And then we go with the rebuttals as well, with respect to the procedure.
That is what we wanted. We wanted to have the rebuttals, like for the procedure and the substantive issues towards the end.
All the procedure as well, the merits?
Yes. Like go ahead with the submissions first and then we'll delve into rebuttals and sur-rebuttals.
Well, I suggest that for the convenience of the panel to actually indulge with the rebuttals as well, it happens just after the procedure with respect to the procedural rebuttals, and then just after the merits with respect to the rebuttals of the merits.
But the only contention that we had was that some of the procedure and the merits issue are overlapping, sort of linked to each other. So maybe if we hear the entirety of the submissions, it will help with the rebuttals and sur-rebuttals also, if you may be open to that. Otherwise,
So how do you propose the rebuttals as well, the sur-rebuttals? Like we go 3 minutes, then you go 3 minutes, or in the end as well?
See, if you are not able to reach a consensus, what we suggest is let the claimant start their submissions and then you go for rebuttal. It's up to you.
So like,
Because we find that there is no scope for procedure as well as the merits of the matter. Both are interconnected. So whoever wants to start, you can start. Because obviously you are defending it.
yeah.
Either you can defend it and then they can present the rebuttal, or they can start so that you can defend in whichever way you are convenient.
so what would are you guys okay with going with RCCR, and then we can the procedure rebuttals and sur-rebuttals, and then the merits rebuttals and sur-rebuttals?
Yeah,
If
fine,
that's okay.
Fine with me.
Okay.
Judges, please note that the format for today's proceedings is RCCR with the rebuttals following the.
Rebuttals.
All right,
In the same format.
Following the RCCR format. Thank you.
If there are no further questions or clarifications, we request the arbitral tribunal to kindly take over the proceedings. Thank you, and we wish both the teams the very best.
Can we start?
Yeah.
If it works. Okay. So I'll be starting right now. Members of the tribunal, a very warm good afternoon. I'm representing the respondent in the present case, and today I'll take 20 minutes to present the two procedural submissions. Now, before dwelling into the submissions at hand, I would like to state that the facts pertain to the voyage of MV Pragya, carrying cargo under 4 separate bill of ladings from Taiwan and Philippines to Australia. Now, this voyage was first disturbed by a justified deviation undertaken in response to a cyclone warning and the need to protect the perishable cargo. It was only thereafter, during the altered voyage, that an unforeseen fire broke out, later actually traced to the hazardous nature of the STID and the inadequate disclosure of the cargo, forcing the respondent to seek refuge at the nearest safe port. In the midst of this maritime emergency, the respondent acted to preserve the vessel, the crew, and the remaining cargo, and subsequently disposed of affected goods under the lawful lien and commercial necessity. With this, keeping this in mind, the Council today has 2 submissions to make. Firstly, that the proceedings under the 4 bill of ladings, they should not be consolidated into a single arbitral proceeding. And secondly, that the order of the emergency arbitrator was not violated and therefore no sanctions are warranted upon us. If the members of the tribunal are well versed with the facts, the council will now begin with the first submission at hand. Much obliged. Now, the first submission pertains to the 4 arbitrations that commenced under the bill of ladings and how they should not be consolidated. At the outset, it is submitted that the claimant's case, it rests on an attempt to artificially unify 4 distinct contractual relationships, each arising from a separate bill of lading issued at different times, at different cargo, at different places also. Now, such an approach not only stretches the scope of SEAC rules, but also undermines the foundational principle of arbitration. Therefore, this issue can be dwelt into 2 limbs. Firstly, that the dispute did not arise either from the same transaction or under the same legal relationship. And secondly, consolidation will cause substantial prejudice to the respondent. Moving forward with the first limb at hand, members of the tribunal, it is respectfully submitted that the procedure governing consolidation has been granted under Rule 16 of Singapore International Arbitration Center Rule, which the clause C of which states that proceedings can be consolidated if the agreements are compatible and if the parties either share the same legal relationship or are within the same series of economic transactions. Now, the respondents at hand are not contesting the compatibility of agreements. However, it is not the only requirement that needs to be satisfied. Moving forward with the first limb, the test of the same transaction or the series of transactions, it requires a unified commercial operation such as a chain of interdependent contracts. However, in the present case, the 4 bill of ladings, they are not part of a single integrated transaction, but they represent independent shipments involving different cargo, different risk, and different contractual context. Therefore, the threshold for consolidation is not being met because at the outset, it is submitted that the bill of lading constitutes each bill of lading constitutes a separate and independent contract or independent evidence of contract of carriage.
But
Now-
at the end of the day, it is for the same cause of action, isn't it?
Members of the tribunal,
Do you have an argument that it's a different cause of action on this? You admit there is only one cause of action, am I correct?
members of the tribunal, the respondents do not agree to the fact that causation for all bill of lading remains the same. Now, to answer that question, the respondent will like to paint a picture before the tribunal. Suppose the issues under issue number 3 and 4 are to be consolidated. Issue number 3 concerns the seaworthiness of the cargo at hand. Seaworthiness of the cargo is only in relation to the STID, not in relation to the bananas, not in relation to the fast fashion clothes.
But that is a different argument altogether. So what is the cause of action here according to you?
Members of the tribunal, the cause of action for each goods, they differ at hand. For example, STID, the classification of the good as a class 9 agent and therefore the fire breaking out, that constitutes as causation. However, for the bananas, the inherent Panama disease that was ongoing at the Old Hamster port, that constitutes causation. So even causation for the 4 different bill of ladings and the 4 different cargo, that differs at hand.
But at the same time, see, when it clubbed together, when it consolidated together, don't you think that you can take defense of the limitation of liability, even the package limited liability that you can take on the reverse side of the BL? It is beneficial for you, then why do you oppose it?
Members of the tribunal, to answer that question, the respondent would like to state that what the respondent today are seeking is not a limitation of liability, but a set-off. We do not agree that we owe anything towards the claimant at hand because the amount that we appropriated from the contractual lien, and my co-counsel will further dwell upon it, was around 1.5 million USD dollars. The same amount was owed to us because the cargo was freight collect. It does not even delve into the fact that we had to pay extra 29,000 USD dollars to the port authorities and damage was caused to our vessel also. Therefore, we're not claiming a principle of limited liability, but a set-off at hand.
Now, counsel, just 1 second. We are not able to comprehend what actually you are trying to impress upon us.
Yes.
The fire occurred after the route diversion was effected because of the cyclone warning.
Yes.
By the time the goods under the 4 bills of lading were already put into your vessel, it was loaded. So then how can you split up the cause of action?
Members of the tribunal, now,
If it's a case where the incident had occurred before loading of one of the goods covered by different bills of lading, of course we could have appreciated that. But the incident occurred after the entire goods were uploaded, isn't it?
members of the tribunal, again, causation here should not be looked into the fact that whether the claims were bought after the ship was docked or not, but rather the actual temporal and geographical timing at when the claims did occur. Now, with regards to the seaworthiness or the deviation at hand, they occurred when the cyclone warning was triggered, and therefore we had to choose route 2. The fourth issue at hand, for that, the causation is entirely unrelated to the misappropriation of goods that the claimant at hand are claiming. Because if members of the tribunal will refer to annexure number 11,
The claim is basically built upon your action of selling the goods contrary to the orders passed by the emergency arbitrator.
members of the tribunal, it
So
must...
therefore,
Yes.
the claim is lodged basically because of your hastiness in having the goods disposed of. So how does it relate to the cause of action actually? The claim is on a different perspective altogether.
Yes, so Mr. President, in regards to that, if Mr. President can refer to annexure number 5, that is present on page number 30, the delivery date for the clothes and all of the cargo actually is 21st of January 2026. We docked at the port of Bay On 15, we docked at the port of Bay on 13th of January. On 14th of January, an emergency arbitrator order was passed against us. Now, if members of the tribunal can refer to annexure number 11, the council requires a moment for indulgence.
Page 49.
Page 49. Yes, members of the
Yes.
tribunal. Now, these refer to the email exchanges between the clothes merchant, shipper, and the carrier post the fire. If you may refer to the dates at hand, these email exchanges took place on 15th of January 2026. After the emergency arbitrator passed the order, the shippers and the consignee abandoned the claim, and therefore we were left with the choice either to adhere to the order that was commercially impracticable for us to follow, or to go with per their wishes and mitigate our losses. Now, this actually brings the council to the second submission at hand. So if the council, if the tribunals agree, I can quickly direct to that issue.
From annexure 11, which communication you are referring to? There are
Email
altogether-
exchange number 3 and 4.
What does it say?
Yes.
Please take us to that.
Yes, members of the tribunal. So
15th January 2026.
on 15th of January, third email was sent from the consignee to us, where they, in line number 2, they had clearly stated, our client has refused to accept the delivery of the clothes post the contract delivery. On fourth email, that again was addressed on 15th of January, it has been stated on line number 4, we can chuck the shipment, and the consignees and the shipper basically do not want the goods anymore. Therefore, it was abandonment of good. And if the members of the tribunal can also refer to the terms and condition, that is annexure number 3, present on page number 27 of the case record. Clause number 16, that pertains to lien. It has been clearly stated that the carrier shall have a lien on the goods and any documents relating thereto for all sums payable by the merchant to the carrier under this or any other contract, and for general average. The general principle of lien is we have the right to retain or dispose of the good if we have not been paid. Again, as I've already directed the members of the tribunal to annexure number 5, all these bill of ladings, they were freight collect. We have been paid nothing until now, and they are now seeking damages.
But no notice has been issued. Have you ever issued a notice? It is nothing has been mentioned on the case study about the notice of freight.
Charges.
Notice of
Notice of freight, because if you want to exercise a lien
yes,
on
members
the
of the
non-payment
tribunal.
of freight,
Members
this
of
is
the
a mandatory requirement to
yes.
issue notice.
Members of the tribunal, because the abandonment of good from their side took place in such an informal way over the course of emails. Even we have responded through an email itself on, again, page number 49, the last email where we had stated acknowledged. That is, we acknowledge the abandonment of goods, but we cannot pay any sum.
Which email?
The last email. Acknowledged, we understand that the shipment of clothes is absolute now. Now, if the tribunal is with me, I would also like to quickly state how consolidation will also cause substantial prejudice to us. Now, this limb can be dwelled into 4 parts. Firstly, it must be noted that consent is the cornerstone of international arbitration, and parties agree to arbitrate dispute only within the scope of arbitration agreements that they themselves have concluded, and not otherwise. In the present case, we consented to arbitrate dispute arising under each bill of lading individually, not together. Secondly, it must also be noted that consolidation in the present case would also risk conflation of evidence and legal standards that are applicable to different cargo shipments. For example, if members of the tribunal will refer to annexure number 15, that is present at page number 59 of the case record, that concerns the hazardous report granted by the services of Anu Lee and Company.
Page number?
Page number 59, members of the tribunal. Now, this report may improperly influence the tribunal's assessment of entirely unrelated claims concerning the bananas or the clothing, because again, the ship was seaworthy for bananas and the fast fashion clothes, and this has been accepted by the claimants at hand also. In the case of BST Textile Mills versus the Cotton Corp at paragraph number 30, that is also provided in page number 9 of our compendium, the court had clearly recognized that consolidation will prejudice a party where disputes arising from different contracts, they involve distinct factual and legal determination. Therefore, such evidentiary spillover would significantly prejudice the respondent's ability to present separate defenses under each bill of lading. Thirdly, it must be noticed that consolidation is a specific procedural mechanism that is governed by Rule 16. Now, the unilateral act of filing a single notice of arbitration, it cannot override these requirements. This position is supported by the decision in the case of EasyBiz Investment Limited versus Sinogram. That is again also provided in page number 3 of the compendium at paragraph number 9. And if I may read out for the benefit of the tribunal, it has been held that the single notice of arbitration referring to disputes under multiple bill of ladings does not give rise to a consolidated arbitration. Instead, such notice is treated as commencing multiple separate arbitrations corresponding to each bill of lading. Applying that principle here, the claimant's filing of a single notice of arbitration, it merely initiates multiple arbitration. It does not merge them. The respondent also keeps in mind that a very common question may arise that what about the efficiency of the tribunal at hand if the proceedings are not consolidated?
So that is what the point which I wanted to ask you. See,
Yes.
even if you look at the SIAZ rules, the consolidation is a procedural aspect which needs to be done by the institution, not by the arbitrator,
Yes.
isn't it? This is a case where initially the application has been filed by the consignee,
Yes.
name so and so name. But subsequently, the claimants step into their shoes and then contested the matter. If that be the case, don't you think that it is a question, it's a procedural questions which needs to be addressed by the institution, even going through the rules? Rule 16.3.
Rule 16.3, again, yes, members of the tribunal. Under Rule 16.3, it also must be noted that the parties require to...
Move on to your next point. We'll come back.
We'll come back to that.
Okay. So regarding the efficiency of the tribunal at hand, the council also is very mindful of it, and therefore it would like to point out rule number 17 of the SEAC rule that permits coordinated proceedings, whereby arbitrations may be heard concurrently or sequentially while retaining their separate identity. So if efficiency and saving time and cost is the only requirement of this code for considering consolidation, then rule number 17 very much answers it. Now, moving forward with my second submission at hand, I have already stated how the order of the emergency arbitrator was commercially impracticable for us to follow because there was abandonment of the goods. I would also like to quickly point out that the order of the emergency arbitrator was also rendered ex parte. Now, within the Singapore International Arbitration Act, read with Article 18 of the Unilateral Moral Law, it mandates that each party shall be treated with equality and must be afforded a full and fair opportunity to present its case. In our case, we were not provided with such an opportunity because even if you look at the facts at hand, the order was passed on 14th of January. If members of the tribunal will refer to the procedural order that is present on page number 54. Point number 4, it states that, point number 3 actually, apologies, members of the tribunal. It has been stated that the respondent was invited to submit observations on the applications by 14 hours Singapore time on 14 January 2026. The application itself was submitted on 14th of January 2026. Effectively within 2 hours, we were required to come up with an entire set of defense while we were docked at the port of a developing country. If members of the tribunal will refer to Schedule 1, Rule number 31, it states that EA shall provide an opportunity that is practicable. What is practicable has been defined by the Black's Law Dictionary. It states that it doesn't mean as soon as possible, but rather it implies a reasonable amount of time. It is the humble submission.
Some of your representatives could have done it.
Members
Nothing
of the tribunal.
prevents you from, nobody asked you to directly respond to the notice, but your agent or somebody authorized person could have responded to that.
Members of the tribunal, again, firstly, with regards to the third point, we were required to do so by
And
2
just 1
p.m.
second,
in the...
you can also take note of this. At any point of time before the tribunal was constituted, you did not attempt to have the order recalled, because ultimately it is for the tribunal to decide whether that order should be made final or not.
Yes, members of the tribunal.
That's only a temporary arrangement between the claimant and the arbitrator. But
Now-
you can proceed. You can take your own time. But your conscious act of ignoring it can be just brushed aside lightly.
Now, members of the tribunal, the council firstly seeks an extension of
Yeah, you
nearly
can
1 minute. Now, to answer that question at hand, it must be noted that the port of Bay, where we were docked on 13th of January itself and when the application was filed, it is a port of developing country. The port authorities had been shut down for 6 hours. That means effectively till the next day, we had no means of internet connections whatsoever. On 14th of January, we received the internet connections. Our first means of even responding to the claimant, leave the emergency arbitrator at hand, was made on 15th of January because we were under such an urgent situation where we had to rectify the damages, where we had to pay off the port of authorities, and we had to look after where we can even store the bananas and the fast fashion clothes. Now, such an amount of time, it does now amounts to a reasonable amount of time. Law here, it does not look into possibility, but practicability. And that is the mere submission of the council today.
Yes.
If the tribunals are satisfied with that answer, the council would also like to summarize by saying that again, the order of the emergency arbitrator was also jurisdictionally flawed because it has been mentioned under Rule 16.6, Schedule 1, Rule 13, that even the emergency arbitrator is supposed to have the powers and the functions of a normal tribunal at hand. So even the emergency arbitrator itself was supposed to look into Rule number 16, decide whether consolidation should happen or not, and then grant the order. What the
Also,
emergency...
the consolidation is not being considered by the emergency arbitrator.
Mr.
Is it not?
President, it is being considered by the emergency arbitrator. It has been referred in,
Let us see
again, procedural order.
Let us see clause 16.
Members of the tribunal, annexion number 13, that refers the emergency arbitrator's order. Page number 55, on paragraph number 8, it has been stated that the emergency
Counsel,
arbitrator...
just read.
No, just finish your point. I'll come
Yes.
there, yeah.
It has been stated that the emergency arbitrator is satisfied on prima facie basis that the disputes arising from these bill of ladings are related and they arise from the same voyage. He did not look into the technicality of rule number 16 at all.
No,
When
counsel-
he was required...
Counsel, that now coming to the, am I audible?
Yes.
Yeah. See, coming to the powers of the emergency arbitrator, it can be split up under two heads.
Yes.
One is the granting of urgent relief,
Yes.
which you have sought, which the claimant has sought. And the second head of power is consolidation. Okay, so now nowhere in this paragraph that you just mentioned does he claim that he is consolidating. He says he can consider it. Consider it for what purpose? For the purpose of granting
The
urgent
interim
relief.
measure itself.
Okay.
Yes.
So that is sort of a misrepresentation. Nowhere has the emergency arbitrator stated that he is consolidating.
Members of the tribunal,
Yeah.
what must be noted is not how the facts are stated, but rather the interpretation and the effectuation of the order at hand. When the emergency arbitrator considered all four bit of pleadings, it ultimately did result into consolidation.
No, tell me something. You are arguing against yourself actually. Do you agree, for the sake of argument, let us say that the emergency arbitrator believes that he has the power to consolidate. Do you agree with that?
Members of the tribunal, emergency arbitrator only has the power to consolidate when he refers to rule number 16. And that is the submission
No.
of the council today, that he did not do so at
No,
all.
counsel, if I bring you back to rule 16,
Yes.
it clearly states that consolidation is done by the court, not by the tribunal.
Yes, members of
Okay.
the tribunal.
So, consolidation is an institutional decision, not a decision that is taken by the tribunal. So, in any case, the emergency arbitrator did not have the power to consolidate.
Yes, members of the tribunal.
And even if we agree to your interpretation of that paragraph, then that would be that he has acted ultra vires.
Yes, members of the tribunal, and that is the submission of the council today, that he acted ultra vires. There is a jurisdictional
you're
flaw.
taking it from me. The point should have come from you.
Yes, members of the tribunal. The council would have liked to conclude by this that there was a jurisdictional flaw in that order, and that is why it is not binding upon us. Now, why it is not binding upon us? It can be referred under Schedule 1, Rule number 13. Now, if I may also read it out for the benefit of the court. Just a moment for indulgence. Schedule 1, Rule number 13, members of the tribunal, it states that emergency arbitrators shall have the power to conduct the emergency interim relief proceedings in such a manner as the emergency arbitrator considers appropriate, taking into account the inherent urgency. However, the second line also states, he shall have all the powers vested in the tribunal pursuant to these rules, including the power to rule on its own jurisdiction without prejudice to the tribunal's determination. Now, the normal understanding is he is bound by the powers that is granted to a normal tribunal. The normal tribunal at hand would have considered rule number 16, and therefore he also was required to consider rule number 16 and consolidate and render a decision on consolidation, then proceed with the proceedings.
Now, again, we go back to the issue that he has two sets of powers. Or actually, he has one set of power, which is to grant urgent interim relief.
Yes.
That has got nothing to do with the consolidation.
But members of the tribunal agreed it has got
And
nothing
in
to
fact,
do with
in
the
maritime
consolidation.
arbitration, it is not uncommon that a single emergency arbitrator grants relief in respect of several bills of lading.
However, members of the tribunal, the mere submission of the council today is that he could not have done so if he would have looked into the facts of the case. If we refer to the order of the emergency arbitrator, for example, now the order of the emergency arbitrator stated that we are in restraint of disposing of the cargo in any means, any cargo. Our bananas were not even present.
Counsel,
They had.
Counsel, 1 second, just to follow from what my brother said. See, at the time of issuing the emergency order, is he supposed to look into the intricacies of law and say as to whether the claim should be consolidated or not? He is, in fact, looking at the interim relief because of the urgent need of the situation. So now, if what we are to accept what you say, ultimately then we will have to hold that the emergency arbitrator will have to again go by the procedure and then determine as to whether the claim could be consolidated or not.
Only prima facie.
Prima facie, he is only interested in prima facie as to whether a claim for an ad interim order is made out or not. Now, ultimately, it comes to the tribunal to decide as to whether the claim should be consolidated or not.
Yes.
I think you may have a difficulty in sticking on to that point. You cannot attack the order of the emergency arbitrator on the ground that the claim has been consolidated.
Members of the tribunal, the council today is not claiming that emergency arbitrator consolidated the proceeding, but rather the effect of the order was such that
No,
it
at any rate-
consolidated
at
the
any rate, when it
proceedings.
comes to the tribunal, we are not bound by the orders passed by the emergency arbitrator. Still, if it is,
Yes,
if it
members of
is
the tribunal.
found that the claim cannot be consolidated, we can always split it up.
Yes,
So therefore,
Mr.
at the end of the day, to argue on a proposition that the emergency arbitrator did not have the power to consolidate the claim, I think that will be out of bound. Yes.
So, members of the tribunal, a lot has been said. Now, I would quickly, in 30 seconds, just summarize what I actually want the court to understand. Now, for example, if we refer to the emergency arbitrator's order, it said that we were in immediate restraint from disposing of any form of cargo. Now, STID, because of the fire that had broken out, it was already destroyed. Because of the Panama disease, the bananas had already been destroyed. How could emergency arbitrator, even without considering the facts at hand, would have stopped us from disposing of the cargo when we are not even in possession of it? And therefore, the council submits that the order of the emergency arbitrator is jurisdictionally flawed because of two reasons. Firstly, it made a direction regarding all 4 bill of ladings and not just the fast fashion clothes. And secondly, that since it was rendered ex parte, it did not provide us any reasonable opportunity to respond. Therefore, it is not binding upon us. And under Rule 44.3 of the CAC rules, no sanctions are warranted because we have justified the tribunal with sufficient cause. With that, the council today rests its submission and passes on to the claimant to present their submissions at hand.
Yeah.
If I'm audible to the Honorable Tribunal. Mr. President and members of the Tribunal, good afternoon. I am Speaker 2, and along with my co-counsel, Speaker 1, I am representing the claimants, the Elizabethan Insurance Company Private Limited, exercising its capacity as subrogee for the consignee, that is Theaty Containers, in the present case. As has been agreed upon, I shall be making the procedural submissions in the first 21 minutes, and my co-counsel will address the merits, and we respectfully reserve 1.5 minutes of rebuttal and sur-rebuttal each. By way of very brief factual background, the procedural issues arise from a very simple sequence of facts. A fire broke out aboard the MV Pragya on 12th January, following which the consignee moved urgently before the SIAC court to prevent the remaining cargo from being put beyond the reach of the arbitral process. To this extent, a binding emergency arbitrator order was passed on 14 January and was duly communicated, but regardless, the respondent proceeded on the very next day to unilaterally auction off the salvageable clothes, and it now seeks to fragment what is essentially one casualty-driven dispute into several. I shall be making 2 procedural submissions. First, that the respondent breached the binding emergency arbitrator's order, and second, that the four arbitrations should be consolidated into a single proceeding. My first submission then, members of the tribunal, is that the respondent was in breach of the binding emergency arbitrator's order of 14 January 2026, and that this deliberate contravention of the order warrants the imposition of sanctions under Rule 44.3 of the SIAC rules. I shall make the submission in 4 steps. First, that the order was validly made and immediately binding, and this addresses opposing counsel's concerns of of lack of jurisdiction. If I may invite the tribunal to the text of the emergency arbitrator's order on page 54 of the proposition.
Before that, can I ask a very quick question?
Certainly.
See, what is your locus standi in filing an application before the arbitrator? Basically, if you look at the emergency application order, the applicant is the consignee, the so-called Theaty freight forwarder, whoever it may be. And subsequently, I understand that you are stepping into the shoes of the consignee, and then you are coming in, isn't it?
Right.
But, SIAC rules provides any provision for the same?
On
How can you, because see, when somebody is filing an emergency application, somebody means the actual consignee, Theaty, logistic, whoever it may be, moves an application for a temporary order, emergency order, and which is passing an order, and then subsequently you are moving, probably based on the letter of subrogation, you are stepping into the shoes, and then you are moving the claim. On what basis? Under which provision of law? Is there any kind of a substitution application is allowed? Is it allowed in a suit? If that be the case, if it is allowed in the arbitration proceedings, you have to convince us. On what basis? Is there any provision under the SIAC rules?
Mr. Arbitrator, if I may take a moment, and I shall address this subsequently regarding the exact provision of the SIAC rules that gives us the right. But briefly, before that, to address your concern, the application for emergency arbitration was filed, of course, by the consignee pursuant to Rule 12.1 of the SIAC rules, and following their claims with the respondent, and now eventually the termination of the contract, the respondent, the claimants, that is the Elizabethan Insurance Company now, has then stepped into the shoes of the consignee to then pursue these claims against the respondent, which is our locus standi for pursuing the 4 claims that we present today. The exact text of the SIAC rules, if you may give me a moment and I shall address this subsequently, I can provide the same to you in the course of my submissions, if the same may be permitted.
You may have to convince us on which provision that you are coming into the picture, and that too during the pendency of the arbitration.
Certainly.
There are 2 parties altogether now.
Again, if I may be permitted to address this in the subsequent course of my proceedings, Mr. Arbitrator. Much obliged. Proceeding then to, again, the text of the emergency arbitrator's order, which you will find on page 54 of the proposition. If the tribunal is with me, this page records under the first header the procedural history of the order. And this history evidences that the entire process under the SIAC framework was followed. Firstly, the application was made validly under Rule 12.1 of the SIAC rules. The requisite fee was paid, and the president of the SIAC court then appointed the emergency arbitrator, following which the respondent was duly invited to submit objections. This is crucial to note because emergency arbitration was at all points squarely within the contractual framework that both parties had consensually agreed to. If this is...
Speak a little louder, please.
Of course. This is crucial to note because emergency arbitration was squarely within the contractual framework that both parties had consensually agreed to. You will find evidence of this in clause 22 of the terms and conditions between the consignee and the respondents, which you will find on page 28 of the proposition. And clause 22 explicitly incorporates the SIAC rules for dispute resolution, and of this, emergency arbitration is a core part and has not been excluded by any attempt. Now, the counsel for the respondents will have you believe that the ex parte nature of the order is a violation of procedural fairness. However, this claim goes nowhere because members of the tribunal, procedural fairness here depends on notice and opportunity, and not on whether the respondent chose to or elected to utilize this opportunity. As can be seen in the procedural history on, again, page 54 of the proposition, the respondent was duly notified of the appointment of the emergency arbitrator, invited to respond by 1400 hours Singapore time, filed no response, and only after this did the emergency arbitrator proceed to grant only temporary prima facie relief and reserved all issues of final consideration for the tribunal. To address this, you will find on page 56 where the emergency arbitrator has expressly held that nothing in, and I quote, "Nothing in this order shall be construed as expressing any view on the merits of the underlying dispute, the question of consolidation of the arbitrations, or any jurisdictional issues that may arise," unquote. Proceeding further, if I may refer the tribunal to, again, Schedule 1, paragraph 23 of the SIAC rules, which you will find on page 23 of the compendium.
What do you say about their plea that they were not given sufficient opportunity to respond? Because the application was moved on 14th January. They were asked to report it, to give a report before 1400 hours on the same day. Hardly any time to respond to what you have claimed.
In response to that, Honorable Presiding Arbitrator, firstly, I would like to point out that there is absolutely nothing that the respondents have brought up to prove that there was a lack of internet connection on the Port of Bay, which then furthers the very point that you had, Honorable the Presiding Arbitrator had raised, which was even though the window of time may have been small for them to submit objections, the idea and the mechanism of submitting the same through any form of online communication was very well present. And furthermore, even if it may be accepted that the respondent was unable to provide a full defense to in the emergency arbitration hearing, as I will prove now in my second point under the same submission, the respondent could have very well opted for a mechanism under the SIAC rules, which would have allowed them to plead to the emergency arbitrator to modify or vacate their order, or to even put forward a claim of interim.
Which is that provision?
Certainly. The provision for the same is Schedule 1, paragraph 19 of the SIAC rules. You will find this on page 23 of the compendium or on your copy of the SIAC rules. And with this, to further prove this point, I'd like to move to my
Just once, 20?
Schedule
rules,
1,
right?
Schedule 1,
23.
paragraph 19.
Page number?
page 23 of the compendium submitted by
No,
the claimants.
and also on page 68 of the SIAC rules.
Of this.
CIAC.
68.
Yes.
Plus 90.
It says
Yes.
on top there.
So if the tribunal is with me,
Yes. Yes.
right. So what this mechanism proves is that even after the emergency arbitrator order was passed, the respondent was never free to disregard the order entirely merely because it considered it commercially unattractive. Its remedy then was to avail this very provision, which allows a party to apply to the emergency arbitrator to, and I quote, reconsider, modify, or vacate the order, unquote. And I'd also like to bring to the tribunal's attention the manner and the speed at which the emergency arbitration was appointed. Only after a day of the consignee filing the application was the emergency arbitrator appointed, and the very next day the order was passed as well. This goes to show that at all points, had the respondent elected to utilize this provision of applying for modification, any possible plea could have been entertained in the same time frame, thereby putting their claims to rest regarding the urgency with regards to time of the salvageable clothes and the nature of their value being diminished.
But what about the issue of lien? They are saying that they had a lien on the goods.
Certainly.
And under the lien clause, it says that they can sell the goods however they want. Were you not trying to get an order behind their backs from the emergency arbitrator and trying to stop or prevent them from being able to exercise their lien and sell the cargo for the freight that you did not pay them?
Mr. Arbitrator, I'd like to answer that question in two parts. Firstly, regarding the issue of whether or not the respondents were privy to the order, as I've shown already, they were duly invited to submit objections. And secondly, regarding lien, the claimants concede that the respondents did have a right to lien, as the same is evidenced in clause 16 of the terms and conditions. However, the right of lien does not at any point permit the respondent to move in absolute disregard for the emergency arbitrator's order. And again, their manner of approaching the right to lien could very well have been raising this issue before the emergency arbitrator under the very same provision, that is Schedule 1, paragraph 19, and then the emergency arbitrator could have been would be empowered to determine the issue of lien, and then perhaps provide permission to the respondents to then proceed with the auction. And in the absence of this, the respondent proceeded to auction off the cargo unilaterally, thereby exercising the right of lien in an unfair manner.
They didn't give you notice that they couldn't exercise lien?
No, we received no notice, which is why it happened unilaterally, which is precisely the grievance that the claimants bring up today.
That begs a question. Say, suppose they were entitled, because of the clause of lien, they are entitled to exercise it as a matter of right if a situation arises. Were you supposed to bypass that clause and then go for an order for emergency arbitrator?
Mr.
The
Presiding,
the emergency arbitrator may not know about the fact that they have a right to exercise lien over the goods. So rather it's a case where you have misrepresented the facts before the arbitrator and then obtained an order.
Mr. Presiding Arbitrator, the right of lien that the respondents contain does not exist in isolation, which goes to say that even that at the point where there is a binding emergency arbitrator order expressly restricting them from disposing of the cargo, the right of lien then does not empower the respondents to proceed with the auction regardless on the claim of lien.
In fact, that is the exact question which we were raising. If as a matter of fact they are entitled to have a statutory lien or a contractual lien, can you overcome the contractual lien by moving the emergency arbitrator and obtaining an order?
Mr. Presiding
So
Arbitrator,
therefore, ultimately, that at the end of the day, the order becomes void. They are entitled to ignore it.
And on top of it, do you think that they are obliged to comply the orders of the arbitrator? Because even if going through the International Arbitration Act, Singapore International Arbitration Act, it has to be executed through a competent civil court. It cannot be directly, executable order. They have not taken such a ground, but still, it has to be, even if you go by even an Indian Act or even the English Act also, the directions cannot be directly executable. It has to be executed through a competent civil court.
To answer both those questions, firstly, I'd like to point out that the lien that the respondent seeks to exercise is a creation of contract. And given that the very same contract, the terms and conditions, contained a provision for dispute resolution, which expressly incorporated the SIAC rules, again, by mutual consent of both parties, this expressly binds both parties to the determination of any tribunal that is then constituted under the SIAC rules, which then clearly includes the emergency arbitrator as well. To answer the question further, simply taking the tribunal back to the fact that the dispute resolution clause was included within the contract, any such order by the emergency arbitrator was binding. And as has been mentioned in the SIAC rules as well, I shall take you to the text shortly, that if the emergency arbitrator exercises the same authority as the final arbitral tribunal to pass any orders. If the tribunal is satisfied with this, I shall move on to the third limb of the first issue, which is that the respondent's conduct of proceeding with the auction unilaterally defeats the very purpose of the order. Members of the tribunal, the purpose of emergency relief here, as in any situation, is preservation. And as the emergency arbitrator noted as well, and if I may take you to page 59 of the proposition, my apologies, page 55 of the proposition, which again contains the emergency arbitrator's order. The arbitrator had held, and I quote, that the applicant would suffer harm that would not be adequately repairable by an award
Page
of damage.
55, which clause?
Page 55, fourth header analysis, point 13.
Point?
13. If the tribunal is with me, and I quote,
Yeah.
the applicant would suffer harm that would not be adequately repairable by an award of damages if the cargo is sold. The goods once sold to third parties at auction in a developing economy cannot be recovered, and the auction price may not reflect the true market value. Keeping this in mind, members of the tribunal,
But is it possible to apply this finding if the respondent is faced with a situation where it is absolutely necessary for them to dispose of the goods?
to tackle that point of necessity, Mr. Presiding Arbitrator, we understand that compliance.
Because ultimately the order is not final.
Right.
It's only temporary nature. The tribunal is not bound by the orders passed by the emergency arbitrator. Suppose they are pleading doctrine of necessity. You will have to establish that the order is still binding, notwithstanding the fact that the doctrine of necessity could be applied.
Certainly, and while it is true that compliance with the order may not have been the most commercially prudent decision for the respondent, we never claim that it was. In fact, the emergency arbitrator itself has noted, and I quote again, that the respondent's submission that and this is point 14 of the very same page, which is page 55, that the respondent's submission that the goods are perishable fast fashion items, while noted, does not justify irreversible disposal before the tribunal has an opportunity to hear the parties, unquote. And to prove this very point of why compliance and of why non-compliance.
Now, how does he come to know about, how does he note about this? Please read it again. The respondent's submissions that the goods are perishable fast fashion items.
Right.
Why noted does not justify the irreversible disposal before the tribunal has opportunity. Because it has now come out that they did not even get an opportunity to address before the tribunal. So therefore, from where does the arbitrator form an opinion that the respondent has submitted it?
Certainly. So to answer that question, if I may take you to the previous annexure, which is on page 51 and 52, which contains the application for the appointment of emergency arbitrator that was filed by the claimant. Here, while where the claimant explains the circumstances giving rise to the application, it reads, and I quote, on point 7, that the applicant has been informed that the respondent intends to auction off goods from the cargo at the port of Bay, and the respondent has indicated its intention to appropriate the auction proceeds to set off against alleged damages. Unquote. So again, in the circumstances that the claimant has dictated to the emergency arbitrator to make the emergency arbitrator privy to the situation, it has become clear that the respondent's defense for wanting to auction off the goods is that their value is rapidly diminishing.
So with this, it proves that you had noticed that you were that they are liening the cargo, and then you went behind their back and then got that order from the tribunal, from the emergency arbitrator, saying that, oh, I am worried that they may exercise the lien, and therefore I'm going to go through an ex parte hearing, and I'm going to get this order and prevent them from exercising their lien, or hold it against them for exercising their lien.
Mr. Arbitrator, we do not believe that the fact of moving to the emergency arbitrator was a malicious decision taken only with the intent of prohibiting the respondents from exercising the right of lien. Again, as far as the lien is a creation of the contract, which it is provided, given reference to clause 16 of the terms and conditions, the very same contract explicitly allows the claimant to raise objections through the dispute resolution framework that both parties have agreed to, which means that any plea then placed before the emergency, then placed before any arbitral tribunal could be construed as one party going behind the other's backs merely because there is an application to do the same, which is why we believe that there was no intent to unfairly prohibit the respondents from exercising the right of lien. To move, and very...
One moment.
Certainly.
Having abandoned the goods, having rejected the consignment, how do you justify again approaching an emergency arbitrator for relief in respect of that same consignment that you rejected?
Certainly. Again, while it is certainly true that the consignee had rejected the acceptance of the goods, this at no point authorizes the respondent to disregard the interest that the claimant still holds, because as the arbitrator itself has noted, the claimant would be even aware of the fact that the consignee had rejected the goods. The emergency arbitrator nevertheless proceeds to hold that the claimant would be irreversibly prejudiced if an auction is conducted of the goods, given that it will be done in a distressed economy. And this goes to show that even though the acceptance of the goods had been rejected, the claimant would nevertheless, and the consignee would nevertheless be irreversibly prejudiced, because any proceeds that the respondent collects from this auction would never reflect the true market value, given that they're being sold in a distressed economy.
But from the material at hand, it doesn't appear that you have apprised the emergency arbitrator that you rejected the goods.
While an express reference to the same may not have been made, the observation of the emergency arbitrator that the interest of the claimants would nevertheless be prejudiced exists very well in consonance with the fact that the goods were rejected, which goes to show that even if they were rejected, the claimant nevertheless retains an inherent interest in the goods, which is why they cannot be auctioned off unilaterally.
But your argument completely proceeds on the basis that through this arbitration, you were trying to prevent them from selling off the cargo on an emergency basis, right? They are exercising a lien for unpaid freight. When it's a case of unpaid freight, it doesn't matter what the merits of your case are or not. They were supposed to be paid freight. You did not pay them freight. They have a lien clause. They are allowed to exercise lien and sell the cargo. Recovery for true value or not is not your concern, because it's their freight that is due. They are selling it. If out of the, say for example, if their freight due was $1 million, they sell the cargo, they get only $400,000. That's their headache. But how can you prevent them from exercising their lien on the basis that, oh, you're not going to get true commercial value for that cargo?
Mr. Arbitrator, the respondent was at no point irreversibly restricted from exercising its right of lien, and again the provision of the SEAC rules that I pointed out could very well have allowed the respondent to raise their contention regarding the right of lien and assert this right before the emergency arbitrator. Given that they did not choose to do this, it cannot reflect on the claimants in the form that the claimants in any way sought to restrict them from exercising this right.
See, actually, your contention could have been appreciated, provided the applicant before the emergency arbitrator itself is an applicant before us. So therefore, if you want to move forward, possibly you may have to address that issue and then move forward. Because ultimately at the end of the day, the consignee has refused to accept the goods. The consignor has gone before the emergency arbitrator. He has obtained an order. He has left as such. He is not interested in prosecuting his claim against the vessel. No, we are the insurance company. So actually, what interest has you have now on today before us? What is actually your interest in the whole shipment?
The interest, again, given that we are in a contract of insurance with the consignee, is that eventually the damage may have to be paid by us, that is the Elizabeth Insurance Company, to the consignee. And of course, to pursue their claim further, we have an inherent interest in the same, as we will naturally seek to not be liable for an amount that is as large as the respondents may paint it out to be, which is precisely the locus standi that we have. That is again the right of subrogation.
Is it sufficient? The facts does not disclose that you are being asked to pay the damages to the insured person, who is the consignor?
While the contract of insurance between between us and the consignee is not explicitly mentioned, provided in the factual record, it is been given to us that
Actually, to whom you are liable to indemnify? The consignor or the consignee?
we are liable to indemnify, slightly just before that, Mr. Presiding Arbitrator, to describe the nature of the relation that we had with the consignee. It is one where we had an insurance under an all-risk cargo policy that is mentioned in the neutral factual record, which simply means that we are liable to compensate all claims of damages that take place, of any damage that takes place during the voyage on the ship. To the point of indemnification then, given that we are in an insurance contract with the consignee, the indemnification would ultimately have to happen in the form of payment from us to the consignee following any claim of damages that the respondents may put against us. If I may be permitted to address the second issue of consolidation, if the tribunal may allow me to.
Yes.
Much obliged. Very briefly, and I shall do this very briefly, Honorable Tribunal. My second submission then is that the 4 arbitrations commenced under the 4 bills of lading must be consolidated into a single proceeding pursuant to Rule 16.4. And very briefly, before I move on to the limbs of this argument, if I may take the tribunal to the text of Rule 16.1, which contains the conditions under which consolidation may be allowed by the arbitrator. You will find this on page 24 of the compendium, and I just want to draw the tribunal's attention to the disjunctive nature of Rule 16.1, which goes to show that the 3 criteria, A, B, and C, are alternative gateways to pursuing consolidation, and we make our arguments mirrored on the same structure. Our first point then...
Counsel, if I can take you even one step before that.
Yes.
What is the procedure for asking for consolidation?
Right. So, in the present case, the application for consolidation was made when the claimant filed a single notice of arbitration invoking all 4 bills of lading on 20th January.
No, but what do the SIAC rules state?
Right. The SIAC rule for this is Rule 15.1, if I may take the tribunal to the text of the same.
If you go to Schedule 1,
Right. Schedule
if you
1.
go to Schedule 1, the very first point, it says a party requiring emergency interim or conservatory relief may file an application with the registrar for the appointment. You cannot do it through the emergency arbitrator.
Right.
From the material at hand, you have not filed an application to the registrar for appointment for consolidation.
Right. So the application for consolidation then happens through Rule 15.1, if I may take the tribunal to the text of the same. Rule 15.1, Rule 15.1c precisely, where it allows,
It says, prior to the Constitution, a party may file an application to the registrar to consolidate 2 or more arbitrations.
Is the tribunal referring to Rule
I am
15?
referring to
Schedule
Rule
1.
16 of the SIAC rules, consolidation 16.1.
Right.
And 3 also.
So you are supposed to file an application to the registrar. You cannot do it indirectly through the emergency arbitrator.
Certainly, and the claimants do not contest that the application was made to the emergency arbitration.
So is it regular then? On what basis now are you asking for consolidation?
The basis for the
when
same...
the procedure itself, the procedure prescribed by the rules has not been followed.
The basis for the same is a deemed application, which is then found in the text of Rule 15.1c, if I may invite the tribunal.
Yeah, but is there such an thing as a deemed application in the rules?
Yes, there is, Mr. Arbitrator, and if I may read it for your convenience.
Yeah.
It reads that the claimant shall, and I quote, file a single notice in respect of all the arbitration agreements invoked, and the notice...
Where are you reading this from?
Rule 15.1c.
Page 21.
Honorable Arbitrator.
Page 21.
I continue. Shall be deemed to be an application to consolidate all such arbitrations in accordance with Rule 16.1, unquote. We hold that this is the structural gateway, the textual gateway through which the application for consolidation has been made, and the same has been submitted in the points of claim by the claimant as well.
Where is the notice issued for invoking the arbitration clause?
Just give, if I may get a minute to refer.
Just to see whether 15.3 has been complied with.
If I may get a minute to refer the tribunal
Yes,
to the
please.
exact page. And while I'm aware, the prescribed time is over. If the
No,
tribunal
that's
may
right.
extend.
You can continue with that. Don't be. concerned about the prescription of time by the.
Right. If I may take the tribunal single notice of arbitration. So,
It's confusing.
briefly in the
One is consolidation is separate, notice is separate.
Actually, he has a better point. He could have just said invocation of emergency arbitration and the consultation are two separate procedures. That's what he should say.
He should say, and I pointed it out to them, so he's not catching that part.
if
The emergency clause and the consultation is two different processes. After the emergency, but he is not saying that.
Counsel, what we are trying to inform you
right.
is that the tribunal is not questioning the fact that the emergency arbitrator has passed an order,
Right.
or that you have not regularly asked for the appointment of an emergency arbitrator.
Right.
We are asking only about the point of consolidation. Have
Right.
you followed the procedure prescribed by the rules for consolidation of the 4 arbitrations?
Mr. Arbitrator, to answer that question, if I may first take your attention to the text of the claims that are submitted by the claimant on page 4 of the proposition. Page 4 of the proposition then, on point number 22, reads, and while I'm aware that this is a document submitted by the claimants themselves, it reads, and I quote, "The claimant's filing of a single notice of arbitration invoking all 4 bills of lading on 20th January was deemed an application for consolidation pursuant to Rule 15.1c of the SIAC rules," unquote. For this, I submit that the neutral factual record at hand does not contain a copy of the notice of arbitration.
Which paragraph is this?
Paragraph 22, Mr. Arbitrator.
Yeah,
The
so you are seeking affirmation of an order that is not regular.
So again, to answer that question better, if I may
See,
take...
you are seeking affirmation of the emergency arbitrator's orders, assuming that the emergency arbitrator has the power to consolidate. What the tribunal is telling you now is that the emergency arbitrator did not have the power to consolidate in the very first place.
Right, we agree that the
So
emergency...
where is the question of affirmation? Because if you see the procedure, you should have filed an application to the registrar of SIAC. And then the institution has to take a decision regarding consolidation. The tribunal has no power as far as consolidation is concerned. Neither does the president of the SIAC have the power. It's only the institution. It's an institutional decision, not a tribunal decision. But that you have not followed. So where is the question of us affirming what was not done as per procedure? We can affirm only what was being done by procedure. Do you understand?
And I do. So, Mr. Arbitrator, to answer the first point of that question, we do not claim that the application for consolidation was made to the emergency arbitrator, because the emergency arbitrator has itself noted that any view of the emergency arbitrator on the merits, including any question
Yeah,
of
so
consolidation...
in fact, even the emergency arbitrator has not got into the consolidation.
Right. Then the jurisdiction of this tribunal then arises in the single notice of arbitration that the claimant filed in pursuance of Rule 15.1c, which declares it as a deemed application of consolidation. And the present neutral factual record does not contain the text or the copy of the notice of arbitration. But the jurisdiction for the same...
There is no such thing as a deemed application for consolidation as per the rules of the SIAC.
The rule is very clear. No?
Rule is very clear.
The rule is very clear.
You have to file an application to the registrar.
Certainly, and while I understand the tribunal may not be with me on this point, I shall move on, but briefly before that to draw your attention. Of course. To prove then, under Rule 16.1 subclause C, why exactly consolidation should be pursued, is firstly that the 4 disputes arise out of the same legal relationship, which is precisely the requirement under Rule 16.1 subclause C subpoint 1. Across all 4 bills of lading members of the tribunal, the carrier, that is N&M Private Limited, the consignee, that is Theati, the arbitration clause, and therefore the underlying legal relationship remains the same. And in practical terms, this means that the same carrier has undertaken to carry all 4 consignments for the very same consignee on the same voyage under the same dispute resolution framework. And it is this continuing relation of the carrier and the consignee which gives rise to this dispute. we submit that under the four distinct bills of lading, the respondent's duties as a carrier across all of them and the consignee's continued position fulfills the criteria that Rule 16.1 subclause C subpoint 1 submits. On my second point then, which is the other requirement under Rule 16.1 subclause C, and this is for point 3 of the same text. It states that consolidation is permitted when, and I quote, the disputes arise out of or in connection with the same transaction or series of transactions, unquote. We submit that this requirement is also met because the four claims do not arise from disjointed and disconnected commercial frameworks. They arise from the same venture, which consists of the same vessel. If I may proceed, if the tribunal has any questions.
Counsel, see, the tribunal has no issue with the fact that a consolidation can happen. What we are taking issue with is the procedure that was followed. Okay. So there is no need for you to argue that a consolidation could have happened. Consolidation is allowed. As per the rules, we accept that. What we are questioning is whether you followed the procedure or not.
Again, if I may submit that and this is the position that the claimants hold, which is that the procedure for consolidation here was a deemed application as is explicitly permitted by the text of the SIAC rules itself, where it reads, and I quote again, shall be deemed to be an application.
Yeah, you can move because ultimately at the end of the day, even if a deemed notice, all right, in notice consolidating all the claims were made, then if that is the case, then 16.2 need not have been there in this book. Absolutely. It mandates a separate application.
Right.
Anyhow, you can
move on to the next
on
point.
that.
Let's move on from consolidation.
So the other issue that I was submitting, the one prior to this, was the fact that the respondent breached the binding emergency arbitrator order and that such contravention of the order warrants the imposition of sanctions. To further prove the fact that sanctions must follow under Rule 44.3 and that deliberate contravention of an emergency arbitrator order is not permitted, if I may take the tribunal to the text of the Indian Supreme Court case of Amazon versus Future Retail, which was also concerned with emergency arbitration under the SIAC framework. You will find the text of this on page 11 of my compendium submitted by the claimants. And if the tribunal is with me on page 11, it reads, and I quote, such interim order or award issued by the emergency arbitrator will continue to bind the parties unless it is modified or vacated by the arbitral tribunal once it is constituted.
Which page?
This is page 11 of the compendium submitted by the claimants to the case of Amazon versus Future Retail, which was also concerned with emergency arbitration under the SIAC framework. It is, if the tribunal is with me on the case.
Page 11 you said?
Page 11 of the claimant's compendium. If the tribunal is with me at the court, we submit that it is precisely this.
We have not got that.
My apologies. Page 11 of the compendium, you will find multiple cases mentioned, one of which is Amazon.com versus Future Retail.
That is there, but...
Okay.
Yeah, we have page 11.
All right. I was referring the tribunal to a quote made by the Indian Supreme Court on the point of emergency arbitrator order.
This is what we have.
No, page 11, you have certain judgments.
But there's no quotes anywhere.
Even that Amazon case is also not mentioned here, if I am correct. Yeah, that is there in page number 8, only the citation.
We just have a page for
That
the
is
citation.
2021 judgment, right? SEC.
Yes, the 2021. I apologize, this is the,
Page 18.
there may be a confusion regarding the document that was submitted. It is the compendium submitted on behalf of the claimants.
It should be
If-
page 18. Page 18.
Page 18.
It's 11.
Yes.
Page 18 is a separate case. Regardless,
It is mentioned.
if I may,
Yeah.
certainly,
Yeah,
if I may then
yeah.
refer the
Yeah,
tribunal to
yeah.
the text
Yes,
of the judgment
yes.
itself. It reads, and as I've quoted, that an interim order as issued by the emergency arbitrator continues to bind the parties unless it is modified or vacated. As we submitted to the tribunal, the mechanism for applying for modification or for the order to be vacated was squarely available to the respondents at all points.
See, but then just take that portion by which the emergency arbitrator is appointed 16. No, that is that is schedule 1. Come to schedule 1.
Yes, Mr. Presiding Arbitrator.
SEAC rules.
Yes, I'm at Schedule 1. It provides for an application to be made
Correct,
under Rule
correct, correct,
12.1.
Now, what is the effect of this order?
The order of the emergency arbitrator bound the parties to the
Ah.
determination that was restraining disposal of the cargo and requiring preservation and inventory until the constitution of the final tribunal. And as the SEAC rules itself read, on paragraph 17 of the SEAC rules, which is page
So
67.
just take clause 20F,
My apologies. Clause
the
20.
SEAC rules, schedule
20F, right. Right. It reads, upon issuance of the final award, unless the tribunal determines otherwise. We submit again that the clause which reads, unless the tribunal determines otherwise, goes to show that the emergency arbitrator had binding authority.
See, suppose, that's why, as my brother pointed out, they have made out a case for exercise of their contractual lien. So once it has come before us that they are entitled to exercise the contractual lien, the order of the emergency arbitrator is not binding upon the tribunal. He can always ignore that and proceed with your claim otherwise on merits.
Certainly, and we submit and we agree that the tribunal today has the authority to overturn the decision of the emergency arbitrator, as the honorable tribunal is no longer bound by it, which was precisely the structure of my submission. I first proceeded to prove that the order was made with due authority, and my other submissions then goes to show that there should not be any substance in the respondent's claim of overturning the order, because there was no commercial necessity, as the respondent was at all points privy to the contractual mechanism of applying for modification or vacation of the award. Finally then, if the tribunal may follow me to the text of Rule 44.3, which deals with the imposition of sanctions, and it says that the tribunal, in case of non-compliance with an order, it has the authority to impose sanctions where there is where sufficient cause is not demonstrated.
So that always will depend upon the tribunal's power under 20F.
Right, certainly. And we submit that the tribunal today is empowered to overturn the emergency arbitrator's award.
Yes.
We submit then that sanctions must be imposed for such deliberate contravention of the award, because even after the order of 14 January had expressly restrained disposal and had directed preservation and inventory of the goods, the respondent did not attempt at any point to return to the emergency arbitrator and put forward its claims of sufficient cause. It only assumed for itself that its own conception of commercial justification was enough and proceeded with the auction on these grounds. And if I may briefly invite the tribunal to the US District Court case of Relaya Star, which is on page 12 of the compendium, assuming that the compendium is
Page 12.
page 12, Relaya Star Life versus EMC National Life. There may have been a there may have been a logistical issue with the compendium that was submitted. We have the same copies.
You should have been more careful.
This is what I apologize for the confusion, Mr. Arbitrator. If I may briefly then, nevertheless, the confusion refer you to the US District Court case of Relaya Star Life Insurance and Company versus EMC National Life Company, which is a District Court case in the Second Circuit in 2009.
Whoever has valued your memorial gives a credit for not going through the properly.
I am referring to the compendium that we submitted, not the memorial, Mr. Arbitrator.
Odd. You should have said that.
We don't have it.
Compendium.
We don't have.
No, compendium is.
We were
what
made
you
aware
have
that-
submitted this.
Yeah, we were made aware that the same was submitted to the arbitral tribunal today. We apologize if there was any.
Which one?
No, there must have been two documents. One,
memorial.
It's a memorial.
It's a memorial.
Memorial.
Your compendium does not find a place here.
Hard copy is not there. Soft copy was given to us. Yeah.
Which one?
No, this is the memorial.
It's a memorial.
No, that is the claimant's memorial.
No, and the
This is the
No, this
respondent's.
is,
Yeah, claimant's
he is
memorial,
right, he is
respondent's
right.
memorial.
It's same thing, compendium, only one copy
No,
is
there is
given.
actually along with this one more document.
That is the compendium.
So this is competitive.
All right.
Oh, it's just one okay.
Yes. Page?
page 12 of the compendium.
It is the.
Page 12.
I apologize for the confusion. I was not aware of
The First Majestic Silver
only
Corporation.
the case right above that, which is the case of Relaya Star Life
Realistic
Insurance.
Life.
Yes, this is a
Yes.
US District Court case of 2009.
Yes.
And here dealing with dealing with bad faith that the court found with respect to the conduct of one of the parties,
Yes.
the district court held, and I quote, that the underlying purposes of arbitration, that is efficient and swift resolution of disputes without protracted litigation, could not be achieved but for good faith arbitration by the parties, and consequently sanctions are appropriately viewed as a remedy within an arbitrator's authority to effect the goals of arbitration. We submit that this is crucial for the tribunal today to note, because without any consequence to such deliberate contravention of a binding order, the respondent will enjoy the practical benefit of acting first in contravention of the order, while the claimant will bear the prejudice of a status quo that is already destroyed and is irreversible, given that the salvageable goods have now flowed into third-party hands, and that the tribunal, in any further determination, will be unable to make any meaningful determination on whether they should be returned, dealt with in any other way pending the merits of the case, given that the clothes are now no longer within the possession of either party.
They should harp on facts which says that execution has to be done to the competent civil court.
If the tribunal is satisfied, these are the depth of my submissions within the first issue. However, of course, for the second issue of consolidation, I understand that the tribunal has its reservations regarding application. If I may be permitted, I may address the substance of why consolidation may be pursued, if the tribunal may permit me to do so.
Not necessarily.
Not necessarily. That is
So then with that, I shall rest my submissions.
Yes. Speaker 2.
Sir, actually, we had adopted RCCR, so
Okay,
it's
okay.
respondent,
Okay.
claimant, respondent.
All right. You are Speaker 1.
Mr. President. Mr. President, esteemed arbitrators, I am my team code is Carnegie and I am the counsel for the claimants, Elizabethan Insurance Company. So the right of subrogation, that is Annexure 10, so we have to indemnify the Tihati containers and freight forwarders, which is in Annexure 10. Now what has happened here, briefly Mr. Arbitrator, in 2 sentences, that there is a catastrophic fire in MV Pragya which has resulted in the total destruction of the cargo. And therefore there is a blatant disregard for the rule of law. So I, in the 21 minutes, would deal with the merits of the case insofar as addressing issues 3 and 4, demonstrating that the respondents N&M Private Limited breached their duties as a carrier and took an unjustified deviation, which subsequently wrongfully appropriating the surviving cargo. While I say 1 minute 30 seconds for rebuttals. With respect to my first submission, I argue on the annual of 3 limbs with respect to issue 3. Firstly is that the claimants have firstly is that the respondents have failed to exercise due diligence in providing a seaworthy ship, and alternatively that there is negligence in taking care of the cargo. The Hague-Visby rules, which undisputedly governs these bills of lading, are strict statutory authorities which defines the duties of a carrier, wherein under Article 3, Rule 2 of the Hague-Visby rules, it mandates that the carrier must, quote unquote, properly and carefully, quote unquote, properly and carefully load, handle, stow, carry, keep, care for, and discharge the cargo. Furthermore, Article 3, Rule 1 of the Hague-Visby rules requires that the carrier must exercise due diligence to properly man, equip, and supply the ship. Therefore, the respondent's vessel was woefully unseaworthy in its operational readiness to carry, keep, and care for the cargo. And why I say this is I take this draw this panel's attention to Annexure 15, which is the investigative report prepared by Annually and Company, a firm enlisted by the respondent. The synopsis. If the panel is with me.
Yes.
So it reveals that the investigation report noted a delay in the closure of the magnetic fire doors, the non-closure of the accommodation, the non-closure of the exterior ventilation vents, which was material to the containment of fire. And I will demonstrate it later on. As the muster list not clearly identifying the roles of everyone on board, which, by the way, Mr. President, is a mandatory prerequisite for the carriage of dangerous cargo under Solus Regulation, Chapter 3, 8, and 37. Therefore, this highlights the failure of the...
You're saying it's a mandatory requirement for the muster list to have a designation of who needs to do what, or is it a requirement otherwise?
It is a requirement otherwise as well. Under 8 and 37, those are to be read together. and it is a mandatory requirement to have a muster list and to properly assign the roles of everyone on board with respect to the emergency situations, which the
But
respondents.
council, just because the duties have not been designated properly in the muster list, you also have to prove causation, right? In what way did that affect the firefighting abilities of the vessel? So just because A was supposed to do a certain thing and B was assigned that duty, did it cause any damage to the cargo because of that?
So certainly, Mr. Arbitrator, this is one of my points with respect to unseaworthiness. I am saying
Now,
that.
how does that make the vessel unseaworthy?
So, what unseaworthy means that a prudent ship owner would not let the ship sail into the sea when he knows of the defect.
No,
Now,
this,
what
is,
the
this
muster
is not a defect per se. A muster list is nothing but a list of duties by the crew assigned for various firefighting capacities, right, or responsibilities. So, if it was not updated, it doesn't mean that the firefighting was not carried out, right?
So this is also the second limb of my submission, that the firefighting was not carried out. Now, I understand that there is no statutory requirement for what the firefighting means was there with respect to the carriers, But my simple submission is, and one more thing is, I would refer to the case of E.R. Hamburg versus Compania Sud America, where it was manifested that unseaworthiness is not just physical properties. It can also be unlike a physical state, it is where there are incompetent officers to handle the crew. Now, handle the fire.
No,
now,
that is a settled
agree.
issue. I mean, the definition of unseaworthiness is evolving every day. That's not the point. The point is
Now,
you have to prove causation.
Now, I agree what the panel is looking for here is whether the the muster list not identifying the roles of everyone on board directly affected the controlling of the fire. With respect to that, my only submission is that the initial submission that I am making is with respect to the unseaworthiness in its totality. Now, I do not have the duty or the burden of proof. If there is initial unseaworthiness, then I do not have the duty to prove that the unseaworthiness directly caused, and which is also the Albacora versus Westcott case, that if there is an initial proof of unseaworthiness, then the respondents have the burden of proof on them to prove that they have exercised due diligence in handling the fire.
Now, what the tribunal is pointing out, that doesn't inherently make the vessel unseaworthy.
That doesn't. So I would then submit on the annual 2 limbs with respect to the non-closure of the ventilation fire vents, and then I would take Mr. Arbitrator to page number 43 of the fire report, final report.
Which page is that?
43 of the final report.
This is annexure 6. Measure 6.
Final report is the last page.
Oh, okay, the last page of the filer.
So it's not page 43.
Not
then.
page 43.
It is.
Yeah, it is.
The
If-
10th February 26.
No,
Yes.
no, not.
It's not
If the panel may go to the fire report, there it is page 40.
Fire report or the final report?
Final report.
Final report. Final report.
Final report. It's also the fire report. Yeah.
Fire report. Annexure 15.
That is page 59.
Page 59. Yeah.
My apologies.
Yeah. Go ahead.
So the EMS further indicates that the para 15, the first paragraph itself,
What page? Page number is. Yes.
Yeah.
if the panel has found the line that the EMS further indicates that if the top para 15
2.5. Yes.
The EMS further indicates that if a fixed gas fire extinguishing system is used for incidents under deck,
Sorry, which paragraph you are reading?
This one.
15.
15. Roman 15.
Roman 15.
Yes,
Yes.
sorry, page number, yeah, this one.
Council, in the interest of time, okay, we got your point, but this report also mentions somewhere that the crew attempted to close the,
But they could not.
they could
That-
not.
There is negligence.
Question the seaworthiness
That
of
doesn't
the
question the
vessel.
seaworthiness. How does that affect the seaworthiness?
The vessel and the crew members over here, the vessel was seaworthy when it left.
So, alternatively, if the panel is agreeing to find this on negligence, then I also argue as an alternate argument, if the panel accepts it, that under clause 5.2 of the terms and conditions, there is enhanced liability with respect to the unseaworthiness and with respect to negligence.
So you're abandoning your unseaworthiness?
If the panel does not find it, if the panel is not with me on unseaworthiness, then this panel. Then this panel may appreciate the fact that the non-closure of the ventilation vents is a negligence aspect of it. Now, negligence under Hague-Wisby rules under Article 4.2a, it is that negligence with respect to the management of the vessel is exempted. Now, my submission is that this is not negligence with respect to the management of the vessel. This is negligence with respect to the handling of cargo, and therefore comes under 5.2 of the terms and conditions of the contract.
So you are, sorry.
Yeah.
So you are abandoning that seaworthiness then?
I am abandoning seaworthiness as long as Mr. Arbitrator agree with me that it
On
is
the
negligence,
aspect.
the negligence
Then
aspect.
again, you have a problem with the
Yeah, negligence is also a defense, no? Neither the carrier nor the ship shall be responsible for loss or damage arising and resulting from act, neglect, or default of the master, mariner, pilot, or the servants of the carrier in the navigation or in the management of the ship. So over here, when it was going and it caught fire, you are saying that the crew members were not able to turn the vents off. It has nothing to do with the owners over here having the vessel which is seaworthy or not seaworthy, or that the owners have done the negligence over here. So how would you not fall
So
under this defense?
this is not, this cannot be, this is not a delegated duty, Mr. Arbitrator. The duty is in whole with respect to the containment of fire that
But how
the
is this negligence of the owner in this case? If you are saying the vents were not shut, how is it the owner who is responsible to shut the vents?
But Mr. Arbitrator, the owner would be liable to ensure that there is no negligence with respect to the handling of the cargo. Now, I agree that negligence with respect to the management of the ship is exempted under 4.2a. But I am not arguing negligence with respect to the management of the vessel. I am arguing negligence with respect to the handling of the cargo, or negligence with respect to the management of the ship indirectly affecting the cargo. So what was the International Packers London case? It held that negligence with respect to the management of the cargo indirectly affecting the ship, it does not cover under the ambit of the same
Yeah, but-
exception.
correct.
Understood.
What trying to point out is the handling of the cargo and nothing to do with the navigation of the vessel.
This, yes.
What is according to you exempted is the negligence which occurred during the course of navigation of the vessel. And the management of the ship.
Yes,
Not otherwise.
not otherwise. Which is also 5.2 of the terms and conditions.
Yes.
Council, do you mean by seaworthiness here, like, unseaworthiness of the vessel, that the human unseaworthiness was from the very beginning when the ship owner knew that untrained or inefficient seafarer is on board and they may not be able to take proper care of the cargo?
So this.
Do
wa-
you mean this?
This was a point of contention that I presented to the tribunal. Although I would, with respect to this, add on to it that what generally happens is the Mezzer fire incident, which is the 2018 incident, and the fire report as well. That was a very detailed fire report. Now, what they stated in that as well, there was no muster list. So what they stated that there were additional crew members which could have been properly assigned a role so as to the management of the fire. That is a must. That is the Mezzer Hornum report. That was my contention with respect to the unseaworthiness and the muster list. But if the panel is not with me, then I may.
No, but how do you reconcile this with the fact that the crew attempted to close the vents, but were prevented from doing so? You're on, so on the one hand, you are saying that they were negligent. On the other hand, the investigation report says that they actually tried to close it, but they were prevented from doing so because of the toxic smoke or whatever.
Now,
So how do you reconcile these two?
verily, Mr. Arbitrator, they might be prevented from doing that, but it does not, like they owe a duty to us to close the ventilation.
Yeah, so they
as
tried to
well.
fulfill that duty. They attempted to close the vents.
I am not denying that they did not try to fulfill the duty, but the same, one more thing. If the panel may go back to the synopsis
Yes.
of the fire report, the hatch covers were proven to be challenging to close. The synopsis of the fire report.
Yes.
In addition, yes, the available information, if the panel is with me,
Which line is synopsis?
this is the synopsis, third paragraph.
Ah.
If the panel may go to this third last line, it was further notice, and before that, before the master
Available
list,
information.
available information did not indicate why the same was done prior to the fire. That means that the crew had the opportunity to close the fire ventilation vents before the fire,
So
yet
it-
they did not do it.
So it means you are saying that there was a delay from the point, from the side of the crew member.
Yes, and which is the duty of the carrier, which they have failed.
But anyways, it takes, crew members, if they are engaged somewhere, it takes 5 to 10 minutes to reach anywhere. So
That
don't you think it's a reasonable delay? Or suddenly somebody cannot just go to
But this statement saying that available information did not indicate why the same was not done prior to the fire, it has nothing to do with the vents being open or not and like being the causation of the fire.
Yeah.
It just says that the vents were not shut earlier. He's saying that he doesn't know why it was not closed earlier.
Yes. So I am not even arguing whether the vents were not the causation of the fire.
You're
I am
talking
saying
about handling of the cargo
handling
itself.
of the cargo. Yes.
But is there anything on paper or on record to show that there was mishandling of the cargo? How are you trying to equate that
So
with
what
negligence?
what the duty of the crew is that they must not only care for my cargo, which is the SDID, my cargo as in total, but they also have to contain the fire in order to prevent damage to other cargoes as well. So since I am the subrogi, I have the rights for all the cargo. My submission is with respect to the other cargoes as well, that they have failed in the containment of the fire with respect to which
So
has
therefore
led
they
to.
caused negligence and therefore the other.
Therefore, yes. So with this, I move to the second limb of my argument, which is also a clarification to the previous one, is that the respondents failed to take due care of the cargo because they ought to have known the nature of the cargo given the imputed knowledge of its dangerous nature. Now, I am not arguing whether I should have known or the carrier should have known of the secondary hazards of the SDID. I am arguing knowledge as a subset in a carrier's due diligence in handling the cargo. Now, what this panel would have to look is whether the difference in the degree of the cargo is that in its nature or in its kind. How I'll explain this is from the Athanasia Communos case.
But they have a case that the true nature of the cargo was not disclosed to them.
Verily,
That is
Mr.
also an issue, because the factum of them not taking care of the cargo in the proper manner would come or would arise only if the consignee had, the consignor had disclosed the true nature of what is there in the cargo containers.
Now,
Then how do you equate that?
therefore, the question arises is whether they
It's a
ought
subjective satisfaction of each and every the subject matter of the containers. So therefore, suppose in a given container, suppose it is an inflammable material, then unless the carrier is put to knowledge about the true contents of that container, probably the degree of care which is required may vary.
yes, verily.
So it cannot have been an absolute as an
Yeah,
absolute.
Council, did you not declare the SDID as a category 9 cargo? You did, right?
Yes.
And to the extent that you declared category 9 under the IMDG, the carrier was perfectly reasonable in storing it the way it stored it?
No.
Why do you say that?
So now this brings me to my argument, is the panel would have to look whether the carrier knew or ought to have known of the secondary hazards of the SDID.
But the bananas were spoiled because of some disease.
Fusarium
It had nothing
disease.
to do with the
No,
fire.
this has nothing to do with it.
So then, how would you hold them responsible for mishandling or being negligent with the cargo?
So there were clothes as well that got burned.
Clothes, I agree, but your report for the bananas was purely on disease. It had nothing to do with the fire, right?
No. So I am not. So if Mr. Arbitrator may go to the insurance claim, it does not mention the bananas. It does not even mention the bananas. It mentions the SDID as well as the semiconductors. The semiconductors were burned and the SDID caught fire. And the clothes were
Limited to these two itself.
3: clothes, semiconductors, and the SDID.
But clothes were rejected because they didn't want it or something.
So part of the clothes was burned. The salvageable part that was remaining, that was auctioned by the respondents. So what I am asking this panel to look into is whether the respondents ought to know or knew of the secondary hazards of the SDID. Now this is my submission that they ought to have known of the
What is
secondary.
the legal basis on which you are saying they ought to have known?
The Athanasia Communos case. So what happened in that case, the Athanasia Communos case, and I have by the way of the proposition itself that they ought to have known. I'll just complete
The
my argument.
IMDG code itself does not state any such thing.
No, it does not state any such thing. But I will come with respect to the MSDS that we have provided now. Although it cannot electronically be searched for keywords, but I have fulfilled my duty with respect to the correct identification as per the law of the cargo, and also informing the carrier of the oxidizing nature of the material by the way of the MSDS. So why they should, I'll just come back to that. So firstly, the Athanasia Communos case, it states that what happened in that case was that the carrier shipped coal, and that evolved methane and led to an explosion. Now that specific quality of coal had a higher propensity to emit methane, and therefore the explosion was caused, which was unknown to the carrier or the defendants. It was even still held that the shipper may not be liable when the carrier ought to know or have known. Now in this case, why the carrier ought to know of the dangerous nature of the cargo? Firstly, the cargo is inherently dangerous. IMDG,
On the contrary, Special Provision 135 exempts this. You are saying it's inherently dangerous. What the IMDG says, it is inherently not dangerous.
there is an imputation of danger with respect to the cargo. I am saying that there is that the cargo is dangerous in the sense that there is an imputation of danger with respect to the cargo. Now, why the carriers should have known is from, if you would turn to page Annexure 6 on page 43. This is
43 of?
Annexure 6 proposition.
Yes.
So there are numerous survivor accounts, forensic evidence, and expert warning, which puts an obligation on the carrier. Just the heading part of it.
Yes.
The Danila Bulletin. There are numerous survivor accounts, forensic evidence, and experts warning. That's why I say it puts an obligation on the carrier. Now, if this panel may go to the MSDS, that is page number
What's the purpose
34.
of this MSDS document?
So this is the material safety data sheet. It informs the carrier of what the hazardous nature of the goods is and how to take care of it.
Which Alexa?
And this is page 34 of the mode proposition.
Okay, what we have seen, the 34. Yeah, I've seen that. Yes.
The physical hazards, very last line.
Yes.
Physical hazard, it informs them of the oxidizing nature. It's written oxidizer. Therefore, the MSGS provides by the way or by way of information of the oxidizing nature of the SGID chemicals. Now, if this panel may would also go to page 44, I'm sorry to do this so many times. If this panel may go back to page 44 of the fire report, it's I don't know how this is numbered.
You can just read it out. Yeah.
Okay. As noted in the above table, most manufacturers documented their product to be an oxidizer and recommended that suitable firefighting means for SDID was to flood with plenty of water and not to use dry chemicals, CO2 or halogenated extinguishing agents. This recommendation is similar to that stated in the MSGS for class 5.1 cargo. Now, I have discharged my duty to inform them of what they had to do. I have informed them of the oxidizing nature of it. Even still, now I will go with respect to the what has caused the fire. Even still, it is their actual fault or privity that has caused the fire. Then I am I should get back by the way of quantum, by the way of award, all the quantum that I have lost. So the next part of my submissions is that the fire has been caused by the actual fault or privity of the carrier. Now, why I say this is I refer this panel again to, if this panel may just open the last page of the 46 it is.
Yes.
Para 8, the last line, para 8, numeral Romans 8, last line. The block storage of the SDID constituted one of the physical conditions present which may have influenced the progression and intensity of the fire. Firstly. Secondly, just the para below, para 9 on Roman numerals, exposure, the last line, exposure of SDID consignments to elevated ambient temperature during transit is a recognized factor that may influence the rate of exothermic decomposition. Now why the fire has been caused is because of the self-decomposition, because the SGID is self-decomposed. Now why the SGID self-decomposed is because they have stored it in block storage and the decision by Captain Khali to deviate to a route with 8 degrees higher temperature, which has resulted in the fire. Now the second
How
issue.
do you say that, Counsel? What is the ambient temperature? And if you add 8 degrees, what is the threshold at which this cargo starts decomposing? The temperature threshold?
50 degrees.
SDID?
50 degrees.
50?
52 degrees.
52 degrees.
In the material MSGS.
So even if you take the ambient temperature and you add 8 degrees to it, does it meet that threshold?
In the month of February.
January,
February.
In February, yeah. 30 degrees, 35 degrees. Does it meet the threshold?
Now, it might not, as a cumulative analysis with respect to the block storage as well. What the block storage does is that it reduces the temperature, which leads to self-decomposition.
No, so this is all to some extent conjecture, right? You cannot say for certainty that this 8 degrees of increase in ambient temperature caused the fire. Can you say that?
A cumulative analysis of it, that the respondent have stored it in block storage, which has reduced the self-decomposition.
So what we are asking, is there some document to evidence what you are saying?
Yes, para 8 and para 9 of the fire report only.
No, because you're relying so much on the fire report. The fire report itself says that there is no conclusive evidence of what caused the fire.
Yes, there is. So I have to prove on a balance of probabilities that there is 51% chance that the fire has been caused by the actual fault or privity of the carrier, which can be proved because of the fact that the block storage reduces the temperature of cell decomposition, and there is an 8 degree higher ambient temperature which the original route was not. Which the original route did not had, and Captain Khali took a deviation. So in a cumulative effect,
can we rule on the probabilities without having a strict evidence to support the claim?
there is evidence. Now I have
But
to.
that evidence is not sure. Nobody is sure what exactly caused the fire.
So had the
You are speaking on the probabilities. No, we have to accept your proposition and rule on the probabilities.
So had the standard of proof, had it been beyond reasonable doubt, I don't think that this claim would have sufficed. But because the standard of proof here is balance of probability, that it is more likely than not to have occurred because of this, then I think the panel should find in my favor with respect to uh, the actual fault and privity of the carrier.
Suppose had the ship uh, taken its original route, probably this would not have happened.
Probably.
Then ultimately they cannot also be faulted for having taken this route because they were advised to do so because of the cyclone warning. So then how do you correlate this?
So my submission next, with respect to the deviation, it's issue 4, and my submission is exactly that the deviation is unreasonable.
How can you say that? But ultimately, at the end of the day, if they had taken the other route, they would have fell into the cyclone directly.
What is your basis for saying it is unreasonable?
Yes. So if this panel allows me, I'll move on to the fourth
Yes.
issue. So my moving to the next issue. Firstly, the twofold. Firstly, the deviation is unreasonable. Firstly, is that although the Hague-Wisby rules allows the carrier to choose any route and without informing the merchant, I submit that this panel, while interpreting this contract, applies the doctrine of contra proferens, which is the doctrine in the interpretation of contracts, and for which I may rely to the case of Glenn versus Margaretson, where oranges were carried from Malaga to Liverpool, and the bills of lading in there as well.
No, but who are you saying drafted this contract? This is a standard format contract, right?
This is a standard, but
Then there's
who
no-
would
no
the
drafter.
proference- But who would the proference in this case would be? They would be on whose benefit the section is accrued.
But can that principle be applied to a claim by the insurance company? Normally, that principle is applied against the insurance company in favor of the insured.
So
Not, it doesn't apply to the insurer. Now the insurer has come before us with the claim.
So it
Isn't
would.
it?
So the rules of interpretation would depend upon who the benefiting party in the contract is. In this case, like the Glenn versus Margaretson case, it also had that the bills of lading allowed the carrier to go to any port or ports or stay in any rotation. And what the carrier did in lieu of the same is that it deviated to a route which rendered the oranges unmarketable. And the carrier was held liable in it. And why it was held liable is because the court stated that standard form contracts are, the court stated that with respect to standard form contracts, it is not agreed upon with respect to a specific party, and it is applied in general. So what also has been held in Leduc versus Walt was that the court would have to look on the application of the exceptions and the liberties, that whether the legitimacy of a liberty is from the contract as a whole. And therefore, in this case, what the court would have to do is that construct the rules of construction would weigh heavily against the proference, which in this case would be the carriers. So the first is with respect to the contract itself.
Then again, suppose applying the doctrine of necessity, suppose the route change is accepted because of the prevailing climatic conditions, then what will happen to your principle?
So the second fold of my argument, which is that with respect to the justifiability of the deviation and the necessity part. So under Hague-Wisby rules as well as the common law, what the law is that the danger must be of a reasonably permanent nature, and a carrier would not be justified in substituting a voyage for merely temporary obstructions, for example, the shortage of tugs or a neap tide. And what would also have to be looked is that the danger affects the ship and not the cargo, and a decision as to the justification of the deviation would be taken keeping in mind the nature of the gravity and the inconvenience in avoiding action. Now my submission is that the deviation is unjustified owing to the annual of there being no gravity of danger and there being no risk to the cargo.
On what basis are you saying
Why
that?
I
It
say
says there's a cyclone warning.
Why I say this is if this Mr. Arbitrator may refer to annexes 7 and 8. 7 and
Yeah,
8.
The cyclone warning.
Actually, that would help the respondent, isn't it?
If this panel would look at the Annexure 7, it states that the impact would be difficulty if the panels found that.
Yes.
The impact would be difficulty in navigation likely to small vessels and personal watercrafts, example kayaks.
No.
Page 44.
Yeah.
They have already demonstrated the same actions.
What is saying it doesn't apply to the ships.
No.
Impacts.
No, what you are saying that just because it says that difficulty is there to small craft, you are saying it is not applicable to a larger vessel.
No. I am saying on a cumulative analysis again.
See,
Firstly, annexes.
See, the settled proposition is no dispute. It's a settled proposition. If the master, the carrier, demonstrate the circumstances warranted them to take a longer route or deviation or whichever manner, they are not liable. Right. Only testers, they have to demonstrate the circumstances warranted them to take a longer route or the deviation. Right. Now, in the present case they have justifications. So they don't want to take the risk. No matter whether it affects a small boat or small vessels or a bigger vessel, doesn't matter. Why should they take the risk?
So my submission is that the deviation must be construed with respect to the panel must apply an imputed knowledge of the dangerous nature of the cargo, that a higher ambient temperature would lead to a self-decomposition. This must be an imputed knowledge with respect to the handling of the cargo.
No,
Then
are you
keeping
saying
in
that the
mind-
master of the vessel should give more weightage to the cargo than to his vessel?
Yes, of course, yeah.
No.
So if the fire would accrue, then the ship would
No,
also.
we are talking about the cyclone now. We are talking
We're
about
talking
the
about
deviation.
cyclone.
We are talking about the deviation.
But both of them should be held in concomitance with
No,
each
they
other.
don't even want to take even 1% risk. Why should they?
So arguing on the anvil of the same, they should have the knowledge of the same that 8 degrees higher temperature would lead to a self-decomposition.
By the way, the findings don't actually demonstrate what you've been mentioning. When I'm reading the last page of your final report,
Uh-huh.
it really doesn't come to the it doesn't come to the conclusion that it was because of the 8-degree temperature variance. Sorry, yeah, because of the 8-degree temperature variance that the vessel, the cargo caught fire and all those things that you've been mentioning.
So if this panel may go back to the last page,
Yeah.
para 9, last line.
Let's read from 8 onwards.
I'll read it
And
out.
actually, right above that also it says, from the information gathered, the following findings are made. These findings should not be read as apportioning blame or liability to any particular
Yes.
organization or individual.
This is a neutral
Right.
report.
Yeah, and then now let's read from 8 onwards. It says, most of the evidence was destroyed by fire. It's not possible to conclusively determine the cause of the fire.
Yes.
So it knocks you out over here. And then it talks about some chlorine smell
Mm-hmm.
in the holes,
Then
which talks about self-decomposition.
Yes.
The block storage of SSA constituted one of the physical conditions present which may have influenced the progression and intensity. So it
Yes.
just talks about the fire increasing in intensity because all of them were kept together.
so fire increasing.
But
in
it's not that because they were kept together that they caught fire.
So with the next paragraph.
The
as
actual
well.
temperature at which the exothermic decomposition is initiated is much lower than the values typically declared by the shipper. So your shippers misdeclared it over here. And the presence of free water and or storage of the SSID in large packets or consignments leads to further substantial. So this is all on the shipper. Actually, it's your problem over here.
First part, I would agree if it's on the shipper, but if the panel may read the second part
Yeah,
as well.
exposure of SI consignments to elevated ambient temperatures during transit is a recognized factor that may influence the rate of exothermic decomposition depending. But over here, it doesn't say anything about, there's no conclusive proof that there was an increase in the ambient temperature.
Yes, so there is no conclusive proof of why the fire has been caused. It is a submission that it is more likely that the fire has been caused because of the actions of the of the respondents.
Then again, you are asking us to judge on the case of a probabilities.
It's my only asseveration is that it is more likely to have happened because of their misconduct than because of the misdeclaration. There is no misdeclaration by us as well. The MSDS which we have given to them, now they will contend that it is not electronically searchable for keywords, but the MSDS that we have given, most of the manufacturers have informed them of the oxidizing nature of the SDID.
But
And
then
not
the paragraph says the actual temperature at which the exothermic decomposition is initiated is much lower than the values typically declared by the shipper. So the figures that your counterparties gave to them was technically incorrect. So for them, they were like, okay, I can handle the 8-degree temperature variation.
That's why they initially said there is a misdescription as far as the declaration of the goods are concerned.
But I also argue on the anvil of there being enough evidence with respect to the fire, with respect to the Joman incidents case.
No, do you have a case that notwithstanding the declaration, the vessel, the vessel should have, the owner of the vessel should have taken care to adopt sufficient safeguards because of the declaration of the quality of the goods?
So
You don't have such a case.
I do not argue on the basis of the declaration per se. I argue on the anvil of there being imputed knowledge and there being readily available information in the industry with respect
As
to
regards
the
the
handling
nature
of
of
the
the
SDF.
goods.
Yes, as to the nature of the goods, and therefore it makes the carrier's due diligence to ought to know of
So
these.
therefore, notwithstanding the declaration, why don't you stand upright on the plea that in the nature of the goods that are declared, the owner should, the vessel should have taken sufficient precautionary measures, notwithstanding what is declared in that. You are not sure about your own, the case what is projected.
I am sure so far as I have a higher probability of being correct, but with respect to the submission, I would also like to point out that. Just a second.
What I have said is, let's see, there is a goods in the nature of a sodium SID or SSID. Notwithstanding the declaration, the owner of the vessel, the ship should have taken care of the materials instead of keeping it in, because they are more conversant with the nature of the transport which is happening.
No specific instructions.
So notwithstanding the instruction, they should have taken care to see that these goods require extra and like that. He should have said. He should have stand on that.
So
See, notwithstanding the declaration, what he should have said is, look here, I have declared this is a sodium nitrate or sodium carbonate. He should have taken. So they should have taken, notwithstanding the declaration, they should have taken steps with regard to that. 100%. Because the vessel should have, the owner of the vessel should have known about the nature of decomposing materials which is there.
So we can move on.
Yeah. More.
move on. One last point also, if the liability would have been absolute on us, that is the shipper, then we would have been liable. But after the Hague-Wisby rules, there's qualified liability, which puts an obligation on the carrier as well to know of the nature of the goods.
Yes.
So lastly, with respect to the quantum of compensation, although the Hague-Wisby rules apply it in any situation, my submission is that I rely on the Encyclopedia Britannica case, which stated that the limitations of the liability would not apply in a case where there is a fundamental deviation. In that case, what happened that they stored it in the upper deck and the encyclopedias got wet, and that was considered as a fundamental breach. In this case, the fundamental breach would be the deviation. Owing to that fact, the whole quantum should be given to us in the form of the liability.
So you mean to say that the limitation of liability cannot be made applicable because there is a predominant deviation breach?
Yes.
So that they can't exercise
There is no
the
limitation of
limitation of liability.
Yes. This is my
But you know, the
submission.
deviation in which way? I mean, only the route, or apart from that, is there any other breach according to you?
So, I mean, according to me, there is only one breach. Where it can also be contended that the Port of Bay docking is also a deviation, but I do not contend that. There's
But as
only
a deviation, of course, they are well protected by clause 13. You know, liberty clause is there.
liberty clause. So
Yeah,
that liberty clause must be read against them.
No,
That
that
is the
liberty clause needs to be read along with the Hague-Visby rules and the basic fundamental principles of law.
So whether the deviation is reasonable or not.
No, if they already demonstrate the circumstances warranted them to take such a deviation, and they have already proved it. I mean, see, they don't want to take even 1% chance. Why should they? So they have prima facie, they have already proved the
So
thing.
then my proof against it would be that there are two things. One is the probability is minimal.
No,
of
you can't blow hot and cold air at the same time.
Counsel, the established law is that the deviation should be that of a prudent and reasonable master. Can you demonstrate that by just this weather report?
So
That the master deviated for the cyclone was not prudent and not reasonable.
it was
That is the
not-
bottom line.
It was not reasonable. And why is it not
yeah.
reasonable is because the law is also that you cannot substitute a voyage for merely temporary obstructions.
No, you are saying that a cyclone is always a temporary obstruction, right?
Yes, a cyclone may be
A
a
deviation
temporary
is always made on the basis of weather.
weather, fairly.
So what is unreasonable about this deviation? Is it the fact that this swell of 5 meters, 4 to 5 meters is not enough to justify, or is it that the 30% chance? You're not stating any case. You're just saying that it is unreasonable. On what basis do you say that the deviation was unreasonable?
So I would refer with respect to the case. I would refer to the case of
No, in the present case.
in the present case. So as a cumulative, first of all, the
See, the
weather
facts of another case may not apply exactly over here.
Yes.
Let's stick to the
so
facts
what
of this
the
case.
law is that the shipper may not be legitimate. It would not be reasonable for the shipper to substitute a voyage for merely temporary obstruction. And it has given an example, that case, for the shortage of
I'm
tugs on
asking
Nambyar.
not about that
Now,
case. In this particular case, based on the cyclone warning that was received by the master, was it reasonable or not reasonable?
So it is not reasonable on the anvil of two aspects taken together. One is that the probability was small, and the second aspect is that the cyclone, from the weather report, it stated that the cyclone would not affect vessels like, for example, MV Pragya. The cyclone would affect vessels like fishing ships.
Not exactly, but anyway, we got your point.
Yes.
Fine,
I may
we
just-
move on. Yeah.
Yes.
I may just Annexure 7, it states that
But we have already
Yeah, yeah.
covered, if I'm correct.
Yeah, we've already gone through
We have
that.
Yes.
already covered.
Yes.
Yeah. Let's move on. Yeah.
so with respect, I have already submitted with respect to the deviation being unjustified. With respect to the non-delivery of the cargo, it is a self-explanatory argument that since the respondents themselves allege that there is a lien over the cargo, it proves the fact that there is no delivery of the cargo, because a lien cannot be exercised when the cargo is not with the respondents, and therefore there is no delivery of the cargo. Lastly, with respect to the appropriation of the proceeds, my only submission is that I would refer to the Adjus Georges case, where the court refused the ship owners to carry a lien for a cargo belonging to third parties. Now, in this case, what has happened is that the respondents are exercising a lien over the banana shipment, which got for the proceeds of the banana shipment, which got the fusarium wilt disease. The appropriation or the money that they have extracted is from the clothes, which is both different merchants, and therefore it is a cross lien which is not allowed by the contract. Although the section 16 of the terms and conditions states, and I quote unquote, all sums payable by the merchant to the carrier under this or any other contract, but it is the merchant specifically with respect to the banana cargo against whom the appropriation can be made. And therefore what the respondents have done is that they have salvaged the clothes, they have sold it, and then they have appropriated it for something that is not they are not bound to do. So
No,
Counsel,
what do you say that? Look at the email communications which are being given. Does it pertain to this annexure 11? Page 49.
Yes. So,
The consignee has refused to take the delivery of the clothes, isn't it?
this
Now,
is
what is sold is, according to you, is the bananas.
the appropriation of the proceeds have been done in lieu of the bananas.
Ah,
That the ports were closed and then they had to pay. So the appropriation was done with respect to the bananas, but the quantum that they have received was because of the salvageable clothes. So you cannot exercise a cross lien, even though you can do it with respect to the clause
no, actually,
16.
which cargo did they sell?
They sold the clothes.
They sold the clothes.
Yeah. Yes.
Fashion, fast fashion.
Fast
Yes.
fashion clothes. And they have exercised a lien for the due sums paid for the banana cargo. That got infected with the fusarium wilt disease, and therefore the cleaning of the
freight
port.
was paid for the rest of the cargo. The freight was paid for the rest of the cargo. It was only the banana cargo.
The freight were to be paid after the delivery. Now, when
Correct.
there
So
is no
then
delivery,
How
what
are you saying that it was only appropriate against the banana cargo?
they have mentioned it.
Where?
Where?
Just it's in the points of.
By which communication?
Yeah.
Not with
They have
respect to the
mentioned.
communication,
Yeah.
they have mentioned.
Cross
it.
claim they have made.
Cross claim
Yeah.
of them. Yes.
Yeah, in the meantime, counsel, just answer me one question. When it comes to emergency arbitrator, when it comes to consolidation, you say they're all part of the same transaction. But when it comes to appropriation, you are saying they are different transactions. How do you reconcile these two?
I reconcile these two. In totality, what has happened is to be taken into together. But what the clauses say with respect to the appropriation in a proceed should be held with respect to that merchant, or the construction would be held with respect to that merchant. Now, I am saying that the events were all the same. But how can you go against a contract and use the money which is for another merchant and appropriate it to the
This is part of the same transaction. Same consignee,
yes,
same
the
carrier.
Same consignee might be the same, but you cannot exercise a lien so as to apply it in a cross lien manner, because what the
Consignee would be defined.
No, the consignee is the same for all four.
All
cargoes.
four consignees.
the consignee is the same for all four.
Shippers are different.
Huh?
Shippers are different.
Shippers are different, consignees are the same.
Consignee is the same, then probably even obligor.
Consignee is the same, that's how we have stepped into the shoe of all four.
Correct. Then probably you may have a difficult case. The consignee is one and the same. How do you then split up the claim by saying that they were not justified in appropriating it towards
So I see that the panel is not with me in this point, but as long as
No,
the panel
we are
agrees-
open for persuasion. We just asked you a doubt.
Yeah.
That's all. It is open to you to convince us on that.
So my submission is that the merchants are different. The consignee might be same, but the merchants with respect to the specific cargo is different, and the lien which can be exercised is with respect to the specific merchant.
Fine.
Actually, under the bill of lading, how does that work? What do you mean by merchant? Is merchant defined in the bill of lading to be a separate party?
It has been defined.
Merchant can mean either the shipper or the consignee.
Consignee
Or,
booking
yeah,
party or freight
or any of those
forwarder,
parties, yeah.
whoever
Any
it
of
is.
these parties. It has been defined.
has been defined.
Can be taken as a
So when
consignee.
you say merchant, who is the merchant that you're saying is a different party over here?
So if
Even
this
the shipper
panel,
and the consignee will be a part of it.
Yeah.
Correct.
I think quickly, I mean, because I think we may have to give time for them also, equal time maybe probably. A last question. Can you still justify, because
The shipper is
we are not
different, the
convinced about your
Shipper
locus
is
standi.
Consignee
Sorry?
is the same.
We are not
The
convinced
consignee
about
is
your
the
locus
same.
standi,
Same for
because
all four
how
very
can you
yeah.
justify
person to take
stepping
delivery.
into the shoes of
The
the
shipper.
consignee
The one
in the
who's
later
sending.
stage? Like if you look at the claim,
So all four.
emergency
the same person will
arbitration,
receive it.
your speaker one, in fact, we have addressed that question.
To pay the freight
The
charges.
speaker one
the
is
receiver.
the consignee who has applied for the emergency arbitrator.
yes,
And during the proceedings, he passed an order, and during the proceedings, under which provision of law,
that you came into the file an application.
So
Is it possible in an arbitration proceedings?
it is possible because we
How?
are ultimately liable to indemnify the
That is
carriers.
different. Indemnification and guarantee both are different
Yes,
terms altogether.
yes.
See, if you say I'm indemnifying you, I'm stepping into the shoes, I can understand right from the beginning if you are filing a claim or raising a claim, I can understand. But this is a case where initially the consignee has filed an application, XYZ name. Now later in the proceedings, in the cost title, even the cost title of the claim, it's your name. I can understand your right of subrogation. I agree. But under which provision of law that you come into the picture as a claimant in the arbitration proceedings? Is there any provision under the SAIC? Is there any provision under the Singapore International Arbitration Act? Or is there any provision under the Singapore Civil Code?
That I think is a problem of the draft.
My apologies,
There is a
Mr.
problem in
Arbitrator.
it.
With respect to the SIAC rules, I may not be aware of the specific rule. But if
Drafting.
Problem with the drafting of the law.
No, probably that is a question. No, there is some kind of a justification also. I'm sure that probably they will also answer. I mean,
Now they will pick up on that point.
no, I'll answer. If this panel may go to page 58,
No, we don't expect you to answer this. It's
if you can,
I-
if you can,
I would
you
like
please
to
do it.
attempt
Yeah.
Yes,
If you
please.
can, you can do it.
58 of the,
Page 58.
of the moot proposition. Para D.
para?
D.
Yeah.
The claimant claims as subrogee of the consignee, Tihati Containers,
no.
pursuant to all risk cargo policy.
yes.
Yes, yes.
D, the claimant claims is that is it?
All risk cargo insurance policy.
So the moot question itself is
Correct.
Yes. So the tribunal
so we have to
itself have
assume that-
agreed.
So the claimant claims is subject to consignment.
So the tribunal has themselves agreed with respect to
Alright.
us acting
alright,
as the
okay.
subrogee. Lastly, with respect, I asked this panel to pass an award, awarding us the whole quantum of compensation,
Yeah.
and hold that the deviation was unjustified. With this, I may rest my submissions.
I think we may have to give equal time to them also.
No problem, no problem.
Greetings, members of the tribunal.
You are monitoring the time also, right? We have to give equal time to them as well.
Members of the tribunal, international maritime commerce relies on a delicate partnership between the shipper and the carrier. It is a partnership built entirely on mutual trust and good faith disclosures. We are here today to resolve a tragedy, but it is our respectful submission that this tragedy was not born of negligence by the carrier, but of a fundamental breakdown in that trust due to defective disclosure. Before we examine the legal standards, the claimant has presented a narrative of operational failure, but a fair reading of the record reveals 5 crucial facts that reframe this entire narrative. Firstly, the baseline seaworthiness of MV Pragya. Now, MV Pragya flawlessly completed the first leg of its voyage from Taiwan to Macau. The ship was operationally sound. Moreover, secondly, the official guarantee. The shipper officially and legally certified their cargo as a stable 9 substance on the mandatory packaging certificate. They did not disclose any secondary hazard there. Thirdly, the administrative reality. The MSDS warning was not a mandatory booking field. It was an unsearchable scan. In a digital system processing 6,750 containers, the carrier relies on the mandatory legal declarations. Fourthly,
Was there any indication on your part that it should be digital scan compatible? Did you inform them that it should be digital scan compatible?
although I will come to that in my submissions also, Mr. Arbitrator, but on page if I may request the tribunal to come to page number 42 of the Lee investigative report, it clearly mentions that the last line of the 9th paragraph mentions that MSDS was not a mandatory document for cargo booking. And yet, we would have complied with everything that was mentioned there if it was not a scanned image and it could have been searched for keywords. We could not have searched for
So probably
words.
if you had informed the shipper that it needs to be keyword searchable, you might have got it in that format. Having not stipulated that, how can you fault them for it?
Mr. Arbitrator, the record at hand does not reveal whether it was a prerequisite requirement or whether they were already, they could have been aware of that requirement as well. In this case, we are not arguing whether what the MSDS is whether the MSDS was digitally searchable or not. What we are arguing is that in a ship which has 6,750 containers, we cannot, you cannot expect us to read a document which is not even mandatory at first hand. Secondly, if we were to even comply with it, we could not have searched it for keywords such as oxidizer or any firefighting measures, etc. It is the humble submission of the council that the ship seaworthiness and the seaworthiness, cargo worthiness, etc. of the ship should be evaluated from the standard of a class 9 good, because that is what the actual knowledge of the carrier was limited to, the SDID being a class 9 cargo. Moreover, I will very quickly come to my arguments. Just one more fact that I wanted to point out. The counsel for the claimants mentioned a preference in their favor, which is something that the contract of the bill of lading and the terms of conditions clearly do not have any such favor or bias towards the claimant. And if I may point out to the lien, which is a clause of huge contention here, 16.1 lien at page number 27 of the proposition. Now it says that the lien can be exercised at the sole discretion whether the contractual carriage is completed or not. And I quote from the clause at hand. Moreover, it is also mentioned that the right to sell the goods at a public or private sale without notice to the merchant. We were not required to provide them notice.
Is it mentioned where exactly page number?
Yes, members of the tribunal. It is on page number 27 on the 16.1 clause, the lien clause. And if
is that clause against the public policy?
Yes, indeed.
sorry,
That particular clause which enables you to sell the goods without notice to them in exercise of the right of lien. Is it not against a public policy?
although the council could concede that it is
And at any rate, the facts does not disclose that you have claimed any, as a matter of right, before the sale, you have put the authorized persons notice regarding your right to exercise the lien, and they have refused to pay the freight charges. So therefore, it appears to us that it is unreasonable on your part
It's against the public policy.
yes,
to have sold the goods without notice to them.
Mr. Arbitrator, although it is not the usual maritime practice, the council could concede to that, but it is terms and conditions that they have also agreed to.
It is not the usual practice in the maritime
It is not the
industry.
usual practice.
When you exercise lien over the cargo, you should mandatorily issue a notice. It is not the practice in the maritime industry.
Yes, Mr. Arbitrator, but the council still submits that first of all they agreed to these terms of conditions, and secondly, when they abandoned the shipment, in the emails where they abandoned the shipment, we also sent another email to them saying acknowledged, where And if I may bring the attention of the
Where is that email of abandoning the cargo?
yes,
Page number?
It's there.
Page 49, the email exchange, and the last email on that
Last
page.
email.
Yes, so we mention acknowledged, we understand that the
Remember,
shipment
you
is
got to
obsolete
action.
now. With
Yes.
the, yes,
Acknowledged, yeah.
Page 14.
yes.
last.
With these facts, realities in mind, I will now address issues 3 and 4 to demonstrate that the carrier acted reasonably, prudently, and within its rights at every stage of this voyage. Coming on to issue 3, members of the tribunal, the respondent did not breach its duties as a carrier. Members of the tribunal, the respondent submits that no liability arises under the bills of ladings read with the Hague-Wisby rules, and this submission is structured around 2 limbs. Firstly, that the respondent exercised due diligence to make the vessel seaworthy under Article 3, Rule 1. And secondly, that the loss arose from the inherent nature of the cargo and the shipper's failure to disclose its dangerous characteristics, thereby attracting the exceptions under Article 4. If I may move on to my first limb, no breach of duty of seaworthiness exists.
No, even otherwise, you need not argue on that point, because ultimately the council has given up the claim on the basis of seaworthiness.
Okay. Yes, Mr. Arbitrator.
What about the negligence aspect?
Yes, Mr. Arbitrator, if I may come on to the exact contentions.
The report says that cyclone warning is not intended to cover the big vessels.
Exactly on the point of the cyclone warning, although I am deviating a little bit from my submissions right now, Mr. Arbitrator, if you may come on to the exact report that the claimants have cited on Annexure 7, page number 44. And the date that it was issued on, first of all, is 19th January 2023. And the short message that is given here is that there's difficulty navigation between Mamco and Tanado from Friday to Sunday moderating. This report is not even for this cyclone at hand. This report has nothing to do with the case at hand. It is only telling us what a cyclone warning may look like. What reliance, the reliance that the respondents place upon is on Annexure 8, the news report of the cyclone, which is dated 5th January 2026. This is the report that mentions that a massive cyclone with 48 to 55 wind knots is expected. And in this case,
No, even if you rely on Annexure 8,
yes.
how do you justify your action of deviation in the route?
Mr. Arbitrator, if I may then take up my 4th issue first, if that's okay, because my 4th issue explicitly deals with the deviation in the...
You can address this.
Yes. So, Mr. Arbitrator, deviation in maritime law is never per se unlawful. It is only unjustified when it is unreasonable in the circumstances. Now, we place reliance on the case of Stagline versus Foscolo, which is a landmark case in deviation, where the deviation was undertaken to avoid danger to vessel, cargo, and crew. And this case lays down a 4-pronged test for deviation. This 4-pronged test is, first, the prudent person standard, whether a departure from the contract voyage would a reasonably prudent person controlling the voyage make at that specific time. Secondly, all relevant circumstances have to be kept in mind at the time of the deviation, not in hindsight. Thirdly, the contract terms, which are explicitly in our favor in the case, clause 13 and clause 14 explicitly allow us to take any deviation, as well as clause 13 mentions without any notice to the respondents. And fourthly, the interests of all the parties. The master must balance the interest of all parties concerned in the maritime adventure, the ship, the crew, and the different cargo owners.
But how do you apply this 4th test in Starline's case? Or in your case, how do you apply the test?
Exactly what I'm coming to, Mr. Arbitrator. First of all, if, as I've already shown the tribunal that there was a 30% warning, now the master considered 3 alternative routes. Route 1 meant sailing into the cyclone, risking a total loss of the maritime adventure. Route 3 meant a 1-week delay, leading to a total destruction of the perishable bananas and a delay in the delivery of the fast fashion clothes as well, which were seasonal in nature. Now, Route 2 was selected as it avoided the cyclone, added only 4 days, and it minimized cargo deterioration. In this event, the bills of ladings also expressly confer wide liberty upon the carrier. Clause 13 permits the carrier to proceed to any route, whether or not it is the most direct
Good
route.
close. Okay, fine.
Yes. If I may come back to my issue 3 then, members of the tribunal. Yes.
But still we disagree on the test that has been applied in Starline's case. That is something different. Because that is the case where exclusive, the power or discretion has been given to the master to deviate the case to safeguard the interest of the crew predominantly and the cargo.
Yes. Which is the case in our in the present case record as well,
But you
Mr.
look at the
Arbitrator.
cyclone, it is not applicable to you. Why should you take the second route?
This cyclone warning on Annexure 7 is not even applicable to us at all. This cyclone warning is a warning issued between Mumco and Tornado on Friday, 19 January 2023, Mr. Arbitrator. We place reliance on the Annexure 8 where it is said, and I quote, a massive cyclone with 48 to 55 wind knots was expected in the Mumco area, which is dated 5th January 2026. And here it is mentioned that preparations were being made near the central coast, and there's a 30% warning. It's mentioned that Philippines braces amid the cyclone warning. So what I'm trying to submit is that
75 to 85 kilometer per hour. I think my brother captain would be able to say. Is it a dangerous cyclone?
It is fairly. That would translate to about 35 knots.
Is it that dangerous as a captain?
It could lead to, on a container vessel, it could lead to containers falling down or something. It could lead.
if I may, if the members of the tribunal are satisfied with this submission, if I may move to my third issue then.
Yeah.
Yes. Members of the tribunal, I understand that the respondents do not want to talk about seaworthiness because the ship was seaworthy, it was properly manned, equipped and supplied, and the cargo was stored in in compliance with strict industry protocol. Now let us come to the contentions that is raised by them when it comes to negligence. When they talked about ventilators being opened. Now, if I may request the tribunal to come to page number, actually there's no page number here, on 33. Page number 33 of which is the documentary aspects of the international transport of dangerous goods. In point 9, if the tribunal is with me. In point 9, it says that when solid carbon dioxide is used for cooling purposes, the vehicle or freight container is externally marked or labeled in a conspicuous place, example at the door with the words dangerous carbon dioxide, etc. Inside, ventilate thoroughly before entering. Moreover, when it comes to
how is this applicable over here?
Because we were ventilating the so the contention which was raised
But this is talking about CO2 dry ice.
Yes, because Mr. Arbitrator, we were only told that it was a class 9 standard cargo. Moreover, another contention with regard to the ventilator that the respondent would submit is that in maritime practice, moving through a zone like Route 2 causes some humidity fluctuations. Now, if a carrier completely seals a cargo, hold in tropics, the trapped moisture condenses on the steel hull and drips down. This is called cargo sweat or ship sweat. And it ruins cargo, especially the textiles like the 55 containers of fast fashion goods that we were carrying. Leaving the flaps open was a deliberate, calculated action to protect the cargo, the clothes, under Article 3, Rule 2 of the Hague-Visby rules. The carrier was only ventilating what we were told was legally stable, standard class 9 cargo.
No, but then come to page 30. 32. 32. The concerned bill of lading. Apart from the class 9 declaration, the MSDS was also attached.
Yes.
32 MSDS was attached, and the subject matter of the containers were also mentioned. 6,000,
Yes. So in
6,75,000 kilos of SSD.
yes, with regards to this, moreover, now
So
members-
therefore, weren't you supposed to conduct a due diligence of that and simply fall back on the declaration under the bill of lading saying that they have set class 9 and therefore your obligation is obliterated?
Now, the declaration of dangerous goods, this is a mandatory document that we were supposed to read, members of the tribunal. I will concede to that. But if you would read at the other description, also provided here, it is said that decomposition at 240 degrees Celsius, store dry away from incompatible substances. What was stopping the respondents from mentioning that it's an oxidizer in the other descriptions as well? If it is an oxidizer, why was it not mentioned here? And the answer to that question, members of the tribunal, is the fact that what would we gain from not adhering to class 9 standards or say class 5.1 standards if we were told that it was a class 5.1 good? But now the question is, on a completely commercially prudent basis, what do the claimants gain from misdeclaring this cargo, or at least not providing the secondary hazards to us? They save massive costs. Class 5.1 oxidizers are incredibly dangerous substances because they accelerate fires. Many shipping lines charge exorbitant hazardous premium rates to carry them, and insurance costs skyrocket. Class 9, which is the miscellaneous goods, is the lowest rung of dangerous goods. By declaring it as class 9, the shippers saved a fortune in freight and insurance costs, and they avoided port bureaucracy as well. If we were to consider the what is mentioned in the mandatory document about the decomposition at 240 degrees Celsius, we even complied with this statement.
No, but, if you again come back to the MSDS,
Yes.
clause 7 specifically says about the storage temperature required for keeping it from explosion. Clause 7, please see that.
The handling and storage, Mr. Arbitrator? Yes. So it says that store in an original container in a dry area where temperatures do not exceed 52 degrees Celsius. When have temperatures ever exceeded 52 degrees Celsius, Mr. Arbitrator, is the council's contention. 52 degrees Celsius is unreasonably a high temperature to exceed. In no circumstances has this temperature been reached. What the council claims is that and if the council may bring the members of the tribunal back to the point of MSDS. Now, I do concede that it is mentioned that an MSDS is not attached. But from a commercial point of view, and if we think about the commercial reality, the MV Pragya is a 14,565 TEU vessel carrying 6,750 containers.
One second. Suppose they fail to disclose it for handling the freight charges and the insurance claim. But still,
You look at the invoice, you didn't see, look at the semiconductors only 44,000. You would have 4,72,500 because they know the
value is the ask her.
You look at the annexure 5 freight invoices. You will get at page number 30 and 31.
Page number 31.
What was the freight invoice for the semiconductors and SDID?
Freight invoice in what sense?
Semiconductors, what was the total invoice in USD?
44. This SDID was 4,772,500 USD, and the semiconductor.
The other one is 44,000.
44,000.
yes, yes.
So that means you know there is a risk involved, isn't it? That is why you raised an invoice on a high value. Correct me if I'm wrong.
Could you please repeat, Mr.
No,
Arbitrator?
see, you look at the invoice.
This is only 3 containers, that is 45 containers.
This is the 3 containers and the other one is 45 containers. That is why the value has.
Yes.
Okay. Correct. Okay.
If there's anything else, if there's any other
Fine.
query. If I may then move on with my submissions, Mr. Arbitrator. Yes, and moreover, if there are
Yes.
any concerns of the bench.
Yes.
No. Moreover, under Article 4, Rule 6, the shipper bears absolute
SDAD is more.
Okay, right.
the shipper bears absolute strict liability to properly declare dangerous goods.
Yes.
Members of the tribunal, the fire, I'm now going to my second limb, which is that the fire was caused by the nature of the cargo and the shipper's failure to disclose its dangerous characteristics. Under Article 4, Rule 6 of the Hague-Visby Rules, the shipper bears strict liability for shipping dangerous goods without, with full disclosure of their nature and their character. Members of the tribunal, this also is given in our terms and conditions, which is why the council was also raising the question of why it should be read in favor of the claimants. If I may request the tribunal to come to page number
27.
yes, page number 27, where it is given that
Clause number?
shipper packed containers, no, it's page number 23 and it is clause 8. Shipper packed containers. The container has not been packed by the carrier and the carrier shall not be liable. This is 8.2. The carrier shall not be liable for loss or damage to the contents, and the merchant shall indemnify the carrier against any injury, loss, damage, liability or expense whatsoever if such loss or damage to the contents or such any injury, liability has been caused by the matters beyond their control. Basically, what this clause says is that the packaging and the packaging requirement is completely upon the shipper. So we should also rely on the terms and conditions as well. Now, members of the tribunal, to understand why the carrier is not liable for this fire, we must look at the purpose of the IMDG code.
Have you mentioned in the bill of lading about the
Of it being an oxidizer? No, Mr. Arbitrator, it is not mentioned anywhere apart from the MSDS.
load stock account on the face of the bill of lading? Where is bill of lading? We'll get it.
Bill of lading is
Annexure?
Page
Page
14.
14.
yes, it is page 14 actually. Yes, and it is
Ship on board. Have you mentioned it as
page
load
number.
stock account? That clause is mentioned here.
No.
It is page number 16 actually for SDID. Members of the
ISS,
tribunal.
SDID.
That clause is made applicable only when you have a specific clause on the face of the BL. Is it mentioned here? Load stock on account of the shipper. Have you mentioned anywhere on the face of the BL?
Members of the tribunal, if you may refer to in accepting this bill of lading, this is mentioned in the bill of lading.
That terms can be made applicable only when it is mentioned on the face of the BL, isn't it? Load stock on account of the shipper.
Now, from our understanding of the proposition, and what is also mentioned is that those terms and conditions are a part of the bill of lading. So those terms and conditions
If
apply
that
to.
terms and conditions, that is what is specifically mentioned. You read the
You cannot
shipper-
import certain conditions which are not.
No, those terms
mentioned.
and conditions form the part of the contract. The bill of lading and those terms and conditions. They bind.
No, it is a condition. If a container has not been packed by the carrier, so it's a conditional clause. So
yes.
therefore,
Oh,
it
I
has
understand.
to be mandatorily if you
I
want to take
understand,
such a
I understand.
contention. It has to be on the face of the record on the BL.
Yes.
Load, stock, count on account of the shipper, which has not been here.
Yes.
If that be the case, you can't take such a clause.
if you may refer to page number 42 of the final report.
Page number 42.
Yes, of the final report, Mr. Arbitrator. And on the first clause number 7, in the first line it says that packing and securing of the container was the shipper's responsibility to ensure that the cargo was stuffed and packed correctly. If it is on page 42 of the investigative report. So
Page investigation report or
So-
fire incident report.
It can't
the
be
fifth
page
last
42.
page. It is page 42. Actually, the numbering is a little.
Numbering is different.
Yes, on the
Fire
investigative
report,
report.
right?
If you may refer to the fifth last page. Fifth last
You
page.
can read, you can read just
Yeah, I will read out for the benefit of the tribunal. According to the company, packing and securing of the container was the shipper's responsibility to ensure that the cargo was stuffed and packed correctly.
No, when you have a solid, substantial document on record, which is a bill of lading, then why should we rely on a report by a third party? How can you rely on that?
But in the same manner, then Mr.
No,
Arbitrator,
if
the
you
bill.
want to take, because we are talking about your terms and conditions on your bill of lading, on the reverse side of bill of lading, when there is a specific conditional clause has been mentioned, in order, particularly when it's a if clause, there is a clear black and white if clause. If that be the case, you should have actually mentioned, you can't simply wash off your hands and never know about this cargo.
Yes.
We have already declared the cargo under class 9. So therefore, you can't wash off your hands, say that you don't know the nature of the cargo. Had it been load stock account on the part of the shipper, you should have mentioned on the face of the bill of lading. And you
Also-
can't rely on a third-party survey report saying that, look, this has been loaded. How do they know as a third-party surveyor?
Or at the time of issuing the bill of lading.
Absolutely. They don't know we can't rely on that report, isn't it?
Yes, Mr. Arbitrator, I understand the concern of the bench, of the tribunal, but first of all, in this same paragraph, it is mentioned that it was a globally accepted norm according to the general terms and conditions that all carriers used. First of all.
No,
Secondly,
it cannot be. It cannot be. We would definitely agree had it not been there if clause. If it is a standard clause, we could have definitely admit. But you specifically mentioned if it is not.
It's a drafting.
But whatever it may be, see, we can't only rely on the document.
no,
You should have argued in such a way.
yes,
isn't
I
it?
completely understand,
So
Mr.
if
Arbitrator.
it was a problem with the drafting, you should not taken that a condition.
Yes, Mr. Arbitrator. But in the same scenario, it could an alternative perspective could also be that the bills of lading themselves also don't say that the packaging and shipping is the responsibility of the carrier. There is no explicit mention to that as well.
Yes.
So in that circumstance, we should rely on the terms and conditions that both of the parties have agreed to.
Yes.
If-
Okay, move on.
Yes. However, in this case, the council would also rely on this SDID disaster is not a mere academic hypothetical. In 2022, the global shipping industry witnessed the Maersk Honam disaster, wherein a catastrophic real-world fire was triggered by SDID stored under deck. Why was it stored under deck? Because it was declared as a class 9 benign class 9 good without any secondary hazards. This case is exactly similar to our case on facts. Following the Honam disaster, legal liability rightfully centered on the shippers and manufacturers who misdeclared the goods and not the carriers who trusted them. In this case,
Which case you are referring?
the Maersk's Honam disaster, where
Most column case.
yes, wherein it was SDID which had burned. This was the exact contention, and in that case, the general average and the costs was awarded to the carrier.
It was only with regard to the general average. Here, is there any general average here?
Yes, there is a general average here, Mr.
No,
Arbitrator.
is it where exactly mentioned in the report? Just show.
The terms and conditions, page number.
Which number?
General average was not declared.
General average was not declared, but there is a clause of general average.
Yes, it's not declared.
That is your bill of lading, correct?
Yeah, we are not asking for any costs because we are asking for set off. But the respectful submission of the council is that general average in there is a clause, clause 19 of our terms and
Standard clause,
conditions.
agreed.
Yes,
Standard
and
clause,
in
but
this case,
general average has not been declared in the present case, isn't it?
no, it's not
But
been
Merce
declared.
columns case, the general average has been declared.
Yes, it was
So you
because
can't compare, you can't take Merce columns case in this particular case as well. That was the case where
Probably you
total
should-
loss, if I'm correct.
What
That was
should
a
I-
total loss.
What you should have argued is relying on the proposition in that case.
yes, I am actually relying on the proposition in that case only, Mr. Arbitrator. The general average was awarded in that case because it was not freight collect. The bills was not freight collect. In this case, the bills are freight collect, and we are not even asking them for cost. We're only asking them to set off the bills of lading. Even if we, even
Set
in
off
our
on
point of
what count?
set off for.
Set off on what count?
Should I come to the claims then, Mr. Arbitrator?
yes.
Okay, I will quickly come discuss the claims as well. Now, first of all, under the clause 19.1, general average, when a ship takes extraordinary measures to save the maritime adventure, like fighting a massive chemical fire, the surviving cargo owners must financially contribute to salvage and repair costs. In the MV Pragya suffered collapsed containers, burned structures in hold 1, 2 and 3 and a destroyed accommodation block. And this is also on 31 and 32, you could page number of the investigative report. You can also see the damage that had occurred to our ship. Now, coming on to the sanctions and what the claimant is claiming from us, they're claiming the auction gains and a lot of other things, but the consignee already owes us a debt because there's unpaid freight for semiconductors, which is $44,400. There's unpaid freight for SDID, which is $472,500 USD. Unpaid freight for bananas, $430,000 USD. Unpaid freight for clothes, $544,500 USD. On top of that, the port of base sanctions, which are $29,500, which makes the total hard debt 1.52 million. Now, the auction proceeds, what we gained from the from selling of the fast fashion clothes was 6,700,000 something kinas. Now, that if you convert in USD dollars, it comes up around 1.55 million. The auction proceeds, which is 1.55 million, almost perfectly match the exact hard debt of the consignee, which the consignee owed us, which is 1.52 million. The remaining 30,000 does not even begin to cover the multi-million dollar cost of rebuilding the 3 incinerated cargo holds and the bridge of MV Pragya. We did not make a profit. We are barely asking them to cover unpaid invoices. As per the case record, we're not asking them for any damages. We're only asking for a set-off. Now, if I may move...
Too generous of your claim. Very generous.
Yes, I will end my third submission by supplying 2 cases on negligence. We look to the English Court of Appeal in the Anaquaga case that the complainant cited. In that case, an undeclared instability in calcium hypochlorite caused a massive ship explosion. The court ruled that carriers and their crew are not expected to be expert chemists. They are legally entitled to rely strictly on the primary IMDG classification provided by the shipper. Moreover, Mr. Arbitrator, the last argument in this issue is that the respondent is independently protected by the fire defense. Even in arguendo, if liability was considered, the respondent is protected by the statutory fire defense under Article 4, Rule 2B of the Hague-Wisby Rules, which states that a carrier is exempt from liability for loss arising from fire unless such fire is caused by the actual fault or privity of the carrier. Now, the threshold for this is extremely high, exceptionally high, members of the tribunal. The case of in the Glencore Energy UK Limited versus Freeport Holdings case, the Lady M case, the Court of Appeal held that even deliberate acts of crew members do not defeat the fire defense unless attributable to the carrier's controlling corporate management. This is what the council submits in regards to the muster list.
See, fire defense can be made applicable predominantly when there is a negligence. If there is no negligence, then only, if I am correct, correct me if I am wrong.
But he says there is,
But in the present case at hand,
they have a case of negligence.
That is what I'm saying, Mr. Arbitrator. Even if they make a case for negligence, the threshold is so high that if they have to prove that the carrier's controlling corporate management had actual knowledge of what was happening and we did nothing to stop it. Now, if I may take the members to the facts at hand, we at page number 45 of the investigative report. So that's the second last page. In the first paragraph, it is mentioned that faced with not knowing the cause and source of the smoke, the masters acted reasonably, first of all. Secondly, on the fifth para, on the same page, it says that the crew exposed to smoke and heat showed great courage and endurance to perform boundary cooling and to shoot copious amounts of water. Now, we shot copious amounts of water at them at the fire as soon as we realized that it's the chlorine which is emanating, and it is the SDID which is on fire. As per the master's reasonableness. So we are protected under this
You
statutory
used
defense.
water only for boundary cooling, not for firefighting.
That is because
No,
that-
there was no way you could use water for firefighting. But I'm just correcting you. That it is
yes,
for
yes.
boundary cooling only.
I completely understand. It is also mentioned that it was very difficult for us to use water because it was stored under deck. I stand corrected, Mr. Arbitrator.
That would have been the end of the vessel.
But this is our submission. There is no evidence, basically, whatsoever implicating the respondent's management in this case. So, if I may move to my fourth issue, second limb, we have already covered that the deviation to Route 2 was entirely lawful and justified. If there are any questions to that pertaining to that, if not, then I'll move to my second limb of my argument, that the respondent did not wrongfully appropriate the cargo proceed. Now, members of the tribunal, firstly, the consignee unequivocally abandoned the cargo by refusing delivery and instructing its disposal. If the tribunal looks at page number annexure 11, it is clearly mentioned that the consignee emails chuck the shipment. And in China shipping versus pheasant shipping and the freight queen case, it was held that the refusal of delivery amounts to abandonment.
refusal of delivery,
Amounts to abandonment.
that is the case only when there is a DO issued and the consignee refuses to take delivery of the cargo.
In this
Here
is-
there is no, that is different. Because once the DO is issued, or if the party concerned expresses an inclination to issue the DO, and if the consignee refuses to take the delivery, agreed. But this is a case where no DO has
damaged.
not been issued.
No, the
Case
that
of a
you are
damage of the
mentioning
goods.
is where the cargo reaches the final destination. And after reaching the final
Correct.
destination, then the consignee
Refuses
to
to take
accept
it.
the cargo.
Absolutely.
Yeah.
You got the difference. See,
Yes, I
That
understand.
case probably does not apply here.
yeah, because once the DO is issued, the ownership title of the cargo pass on to the consignee. So when somebody refuses to take delivery order, then the title remains with the shipper. That is what this particular case. It cannot be made applicable here because the cargo has not reached at the final destination.
Yes, I understand.
This is China shipping, right?
This is China shipping, yes, Mr. Arbitrator. Even if the reliance on this case is misplaced and the council completely apologizes for that, the council would still submit that we possessed a valid contractual lien over the cargo and its proceeds. Clause 16.1, as I pointed to the tribunal earlier as well, mentions that it does not matter whether the contract of carriage is performed or not. We were well within our rights to sell our sell the fast fashion clothes and auction off the proceeds. Moreover, we did show inclination to deliver the cargo to them in our emails. We did show inclination. They just said that they don't want it anymore, and that's what we relied upon. Moreover, in the present case, the cargo consisted of fast fashion goods subject to rapid commercial depreciation. When we were docked at the port of Bay, Mr. Arbitrator, it was impossible for us to store that cargo somewhere. The port was shut down for 6 hours. As sanctions were already applied upon us, 29,500, and there were no storage facilities available to us. It was impractical for us to comply with that order.
Yes.
Moreover, the auction preserved 6,704,775 kinas, substantial value which had we not received, we would have had no money, we would have had no way to get out of this maritime peril that we were put in by the claimants as well. Therefore, the carrier is not liable for the fire. The deviation was a justified life-saving measure, and the auction was a lawful mitigating response to the consignee's total abandonment of the goods. Members of the tribunal, to find the carrier liable today is to penalize a party for trusting the very system that makes global trade possible. Imagine handing a sealed package to a courier and you declare that it's a standard document. In reality, the box contains some photographic film. When the courier prudently opens the box for standard security checks, the light ruins the film. Now, you cannot blame the courier for failing to protect the cargo. The courier acted in perfect good faith, treating the package exactly as it was labeled. If the package required extraordinary care, the duty was on the sender to declare it. The carrier in this case was handed a sealed container labeled safe. We protected it, we sealed it carefully, and when tragedy struck, we did everything in our power to mitigate the damage. We respectfully request the tribunal to dismiss the claimant's case, uphold the carrier's good faith actions, and grant our counterclaims. That is the respectful submission of the respondents. If there are no further questions, we rest. It was a pleasure submitting before the tribunal. Thank you.
Yeah, there are no questions, but just something academic. The claimants say that the cause of the fire was the SDID in the container. And that is your position also.
No, that is not our position.
What is your position regarding?
Our position regarding it is that
What is the cause of the fire?
the cause of the fire is something that even the Anu Lee report could not come to, because as it is clearly mentioned in the 7th paragraph on the last page, as most of the evidence was destroyed by the fire, it is not possible to
But in your
conclusively-
memorial, you accept that the cause of the fire is the SDID. Yes. Anyway, now you're taking a different stand. Had you taken this stand, okay, I told you this is academic. Now, if what you just said now, that the Anuli says that the cause of the fire is not known, had you taken that stand from the beginning, then under Article 4(2)(b) of the Hague Rules, the burden of proof would have not rested on you to prove that you are not negligent, that your vessel was not, the burden of proof would have rested on them. But you were forced to this entire proceeding, you forced yourself to justify that the vessel was not unseaworthy, that there was no negligence. You took upon yourself the burden of proof by stating that you know that the fire was there. Had you just said in the beginning, Anuli says, we don't know where the fire is, carrier also says, we don't know where the fire is, the end of your case, then they would have had to, the entire burden of proof would have shifted to them.
Rather than focusing,
You've taken it on yourself.
rather than focusing on their incorrect declaration in the bill of
Yeah.
lading.
Actually,
You should have simply said that all right.
No, I read your memorial last night. You accepted that the SDID caused the fire.
but the The contention actually, what we figured out later actually.
I told you, this is academic.
Oh,
Okay.
if I may answer, if I.
We'll carry on this discussion after this thing.
Okay. We wanted the proceeds set off. We are not claiming anything, but we want a set off. In any case, if. Yes. So.
As the brother said, it is only an articulation of the problem which is presented before you. The first thing which a problem which comes to you, even as a lawyer or as a mooter, what you should be doing is, you should decide how to articulate your stand based on the problem.
Yes.
That becomes
exactly.
crucial, because later point of time, if you find that your articulation is not proper, you will have to resile from your articulation. Then you will be caught up very easily by saying that you are appropriating and reprobating. So therefore, you should be very careful while articulating your stand. That is what my brother was saying. He's more.
Then our submissions would have been very limited then, Mr. Arbitrator. No, I completely understand, although I understand.
Is there a rebuttal is required for that?
Any other rebuttal is required?
Is it required?
Can we start with the rebuttals and sub-rebuttals?
No, on what point you require a rebuttal?
Since they conceded on consolidation, I have a rebuttal on the emergency arbitrator issue.
All right.
Then, can we start?
What is the point of rebuttal from your side? Well, we need not repeat the whole argument once again. On specific issue.
Specific issues, their contention, there are 4 counts of my rebuttals. First is that they have said that the weather report does not apply.
Mr. Arbitrator.
One second.
First, that they have said that the weather report does not apply, which is a very factual rebuttal because there are clarifications.
No, those aspects you need not go. We are not deciding on the issue as such. On legal issue, if you have a rebuttal, you can.
Okay. So there is also a point, they have said that they have cited the Maersk Honem report and they have said that the fire was caused by the underdeck cargo. So I only wanted to point out from the bills of lading that we have agreed to store the cargo over deck. There is no underdeck storage. This is the third rebuttal. And finally, they have failed in their threshold. They have said that I have argued on the anvil of actual fault or privity, but what the threshold here is, accordingly, Hague-Wisby rules, Article 5, it allows us to increase carrier liabilities. So, accordingly, 5.2, if this panel may read, the terms and conditions, it accrues liability for fire with respect to negligence as well. And therefore, they've said that actual fault and privity is not there. Even if negligence is there, then also they are liable for the same amount.
First of all, we disproved negligence in our arguments, so we would not want to. We are not contending that negligence is or is not a threshold. We are disproving negligence. We are saying there is no negligence. Secondly, on the first question that was asked.
She wanted to say something on the consolidation.
No, we'll come back to that. We just sir rebuttals of the merits if we could do. On the first, yes, on the Maersk Honem case and the storage. The storage below deck is only something that is possible for class 9 goods if we would have been told that it's an oxidizing substance, or if it would have if a secondary hazard was declared, then we would have stored it above deck. Moreover, in our terms and conditions, it is mentioned that we may store the good wherever we want. It is mentioned that the storage may be above or below the deck.
Yeah. Counsel, you might want to check later, subject to correction. Class 5.1 substances also can be stored under deck.
5.1.
Yeah.
This is class 9.
This is 9.
What he says is the discretion of the captain to.
No. The IMDG specifies storage and segregation requirements.
It's not the discretion of the
It is
captain.
not the discretion of the
No.
captain. Whether it is under the
no.
What about the normal cargoes?
No, if there is no hazard, then it doesn't. It's not covered by IMDG. These IMDG cargoes, it says two incompatible cargoes cannot be stored together.
Correct. Don't be
Or the distance has to be 3 meters, 6 meters, 9 meters.
Exactly, members of the tribunal. I completely agree, but all I was saying is this further defeats their rebuttal that it was stored above or below deck. Moreover, if I just may add, the contention of it being stored below deck is problematic only because the storing it below deck, we were not able to put water into that.
No, that nobody can fault you on that. With
that
the
is-
carrier is built with certain firefighting capabilities. It has to stick to that only. That there's no need to argue that. Yeah.
Then this rests my rebuttal as well.
There again, they have a problem. See, storing under deck and over deck. The moment in the SSDI, whatever the SSDD, whatever they call, is declared. Does it matter that it is class 9 or class 4 or class 1?
Yes.
So the captain should know about the
So if it is class 9, the requirements are not so stringent.
No, but then as far as that product is concerned, does it have a different classification? That SSDI.
So one is,
No, that's right. For SSDD.
yeah, these are two forms. One is anhydrous, one is dihydrous.
Okay.
Members of the tribunal,
5.1 is anhydrous, that is dihydrous.
Oh, that is why it's classified
That's
5.1 and class
So
9.
this is not oxidative, this is oxidative.
Oh, I see. That is why
Oxidative
it is
means
classified
something like
5.1 and class 9.
So the
Yeah.
dihydrous form is not oxidative.
members of the tribunal, if I may come to the rebuttals for the procedural issues at hand. Since the claimant have already conceded as to the consolidation of the issue submission, moving on towards the order of the emergency arbitrator and its breach, the claimant have put forward the argument that we did not approach the tribunal for modification or rectification of the order. Now, if members of the tribunal will refer to page number 56 of the compendium, which precludes to Schedule 1, Rule number 20, an order or award issued by the emergency arbitrator shall cease to be binding if the parties so agree. Order of the emergency arbitrator was passed on 14th of January. Parties ceased to agree that the goods have been abandoned on 15th of January. Therefore, by this virtue of rule number 20, the order of the emergency arbitrator was not binding upon us.
Yes.
Also, further,
There is Schedule 2C. Schedule to these rules.
Schedule 1, rule number 20,
20F.
20A, it states that an order ceased to be binding if the parties so agree.
And you are relying on the email also.
Emails, yes, members of the tribunal, because they have completely stated that they don't want the goods anymore after the order was passed on 15th of January. Therefore, it implies that both the parties had agreed that the goods have been abandoned.
Yes.
Also, in regards to the fact upon the deemed application,
If the parties so agree. Can you repeat again? On what is your basis?
yes, members
One is
of
if the
tribunal.
parties so agree. Which clause exactly are you
so
relying on now?
We're relying on Schedule 1, Rule number 20, paragraph number A, that states that an order or order issued by the emergency arbitrator shall cease to be binding if the parties so agree.
But are the parties agreeing?
Yes, members of the tribunal, because they have exchanged emails with us on 15th of January.
Council, what you should have said is, you should have persuaded the tribunal to not to follow the emergency arbitrator's order under clause 20F because of the abandonment, not under 20A. It will not come under 20A because there is no agreement by them by saying that.
Yeah, they
the
don't
order is-
agree that you agreed.
Members of the tribunal, because clause F merely states upon issuance of the final award unless the tribunal determines otherwise.
Otherwise.
Now,
You could have
I
said
agree with this, but the mere contention is obviously it's convenient for them to say that we don't agree. But
No,
in
it's
the
for
emails they have
tribunal-
agreed.
If for the tribunal to say whether the emergency arbitrator's order should continue or not.
Members of the
In
tribunal.
the factual situation where
Yes.
they have abandoned the goods by a conscious act of giving you the email,
Yes.
it is open for us to decide as
Yeah.
to whether it should continue or
Yeah.
not.
Yes, members of the tribunal.
That
Now,
should be the way in which
Yeah,
you should
yeah.
be
You
focused.
cannot say that we have agreed. The
As
fact that
regards
you
to
agreed
that-
is in dispute.
Yes, so members of the tribunal, as regards to this, we are merely saying that we could not have approached the emergency arbitrator. We are putting forward this claim before this
No, that
tribunal
you already
itself.
argued.
Yes.
You already mentioned.
Yes,
that, yeah.
members of the tribunal. And therefore, since even this application in front of the tribunal was filed within 5 days, that is on 20th of January. This date right now is technically 20th of January 2026. We did not have, firstly, enough time. Secondly, we could have only approached the tribunal since, according to the shippers, that were the main parties, there was abandonment of the goods.
Yeah.
With that, I rest my submissions.
Members of the tribunal, I have 2 points of responses to what the opposing counsel has brought up. Firstly, we would wish to make it clear that at no point have we conceded the point of consolidation because, firstly, insofar
What do you
as
say about the abandonment?
certainly abandonment. So, with reference to the email that has been made, to which averments have been made, if the tribunal could follow me to the text of the email that the opposing counsel brings up, which is on page 49.
We don't wish to.
Yeah.
Sure.
You may do whatever you
All right.
want.
So the email that they keep referring to is between, it has been sent from an ID that is Fahad at ABC Fashion to the consignee. Fahad at ABC Fashion or ABC Fashion, this company, is not the shipper. As it clearly says,
You've
it is.
not taken this argument till now?
We did not bring up this. So this discourse in the emails was brought up in their submissions, and we wish to point out that this is not between the carrier and the consignee. It is between the consignee and the customer. So the idea, the quote of chuck the shipment or the idea of abandonment has come from the. And this specific idea has been put forward by
No,
ABC
but
Fashion.
At any rate, you cannot find fault with them for having accepted it. It's only a subjective assessment of what the subject matter of the email is concerned.
Certainly. So then, what the consignee then did was refuse to accept delivery. But then, insofar as they approached the emergency arbitrator to get an order to restrain the cargo, this still means that the claimant very well had an interest in against the cargo being disposed. So my second unsimple point of response is to make it clear that at no point have we conceded the point of consolidation. Because firstly, as far as the locus standi of this issue is clear, because as per Annexure 14, which is a procedural order made by this very tribunal, the issue of consolidation is to be heard in the final hearing, by which this tribunal is bound. And as far as this locus standi is clear, we have submitted in very clear terms that since all 4 arbitrations are between the same parties and the same relationship, and because all 4 arise from the same casualty event, consolidation is to be warranted. I rest my rebuttals.
Counsel, we are not deciding the man finally and awarding any compensation to you people. You have done more than sufficient. Yes. Thank you.
Participants and audience, please remain seated while the judges go to the deliberation.
Live streaming is stopped at value mic.
Only for in my bench. Okay, guys, Leah, e-table towards that side.
Hello.
Hello, check.
A very good evening to the honorable members of the bench, distinguished guests, learned members of the faculty, dear participants, ladies and gentlemen. I am Sri Hamsini, the participants coordinator of NIMLAC, and I am joined by Varsha, the public relations coordinator of NIMLAC, as I, on behalf of the NUALS Moot Court Society, welcome you all to the valedictory ceremony of the 7th MK Nambyar Memorial NUALS International Maritime Law Arbitration Competition, NIMLAC 2026.
What began with the release of a proposition over a month ago has unfolded into a competition of extraordinary caliber. From the preliminary rounds to the quarterfinals, the semi-finals, and this evening's grand finale, every stage has demanded precision, resilience, and advocacy of the highest order, and we have before us two teams that demonstrated extraordinary skill and resilience throughout this competition, Carnegie and Bengal Merchant.
Before we proceed, we would like to acknowledge the institutions and organizations whose collaborations has lent NIMLAC 2026 both its reach and credibility. We are grateful to Yusmundai, the Center for International Mediation Arbitration, England and Wales, the Maldives International Arbitration Center for their support in bringing an international dimension to this competition. We are also very grateful to Bosan Mitra Co., IAMC Hyderabad, A for Arbitration, Phoenix Legal, and the Indian Institute of Arbitration and Mediation for their valued partnership. And we reserve a special word of gratitude to the MK Nambyar Trust, whose enduring support for the competition this year is, in every sense, the reason it bears the name it does. We are privileged to have with us this evening Dr. Leena Akka Matthew, the Registrar of the National University of Advanced Legal Studies. Her quiet but indispensable stewardship has been instrumental in making events of this scale possible, and we are grateful for her continued support. We now invite Dr. Leena Akka Matthew to address the gathering.
Honorable Mr. Justice S. Ishwaran, Judge, High Court of Kerala, Mr. Ruchir Goenka, Captain Sushil Shankar, Mr. Joy Tuttle, Ms. Manisha Tiwari, Faculty Coordinator Dr. Sandeep Emin, members of the faculty, staff, dignitaries, Student Coordinator and MCS Secretary, Ms. Alina Sujit. As part of NIMLAC 2026, we have watched teams from across India and even from outside India navigate the complex waters of carrier liability, dangerous goods, and arbitration nuances under the Hague-Visby framework and the SIAC rules 2025. And NIMLAC is known for its challenging propositions, and this year was no exception. Our heartfelt gratitude to the moot proposition drafting team and to the dignitaries on the dais, the distinguished jurists, Honorable Mr. Justice S. Ishwaran, Judge, High Court of Kerala, and the maritime experts who have taken time from their busy schedules to judge the rounds. I extend my appreciation to the NUALS Moot Court Society and the volunteers under the able leadership of Dr. Sandeep Emin, Faculty Coordinator, for all of your tireless efforts in preparing the case, coordinating with the teams, and ensuring that everything went on seamlessly, even when faced with technological challenges. Now, seeing the participants confront the seasoned arbitrators, adapting to difficult questions, and showcasing their meticulous research has been truly inspiring. Now, regardless of those who actually takes the trophy tonight, you have all demonstrated your tenacity, and analytical skill that define the next generation of legal practitioners. Now, the intense battles that have happened during the preliminary rounds, the quarterfinals, and also the final round have all contributed to the rich legacy of this moot. So, in advance, I would like to congratulate the winners who are to be declared. And for everyone else, take home the lessons, the friendships, and the memories of NUALS Kochi home with you. And we look forward to seeing you all again, hopefully in the next edition of NUALS NIMLAC. Thank you.
Thank you, ma'am, for your gracious words. Distinguished guests, it is now a profound honor to welcome to the dais Honorable Justice Ishwaran S. Sir's presence at the valedictory of a competition named after the legendary M.K. Nambyar, here in the very city where Sir began his own journey in the law, is a privilege that the organizers and the participants of NIMLAC take pride in. Ladies and gentlemen, please join me in extending the warmest of welcome to Honorable Justice Ishwaran S.
Good evening, all. Distinguished members in the dais, students. I have always found judging a case more easier than presiding a moot court competition or delivering the valedictory address. It's the second time which I have come before this prestigious institution. I'm really surprised by the quality of the students who participate in the competitions, and also the tenacity which they withstand the questioning which normally we do in the courts. Today's subject assumes significance in the context of the globalization of the economy and also the increasing trade which goes through the sea. Unlike any other law, the maritime law certainly deserves specialization and also involves various international laws as well. It is not confined to one territory alone. So certainly it requires a greater care so far as its applications are concerned. Now, what makes the international maritime arbitration particularly fascinating is its intersectionality. It lies at the confluence of the public international law, private international, as well as commercial law and specialized industrial practices. It doesn't always matter whether you have a great legal acumen, but it always involves the application of various geopolitical considerations. The purpose of these moot court competitions is to equip yourself into these specialized areas. Say 20 years ago, when I was in my college, the concept of the maritime moot court competition, or for that matter, even the alternate redressal mechanism like the arbitration, was unknown, because it was just starting its application, and also the influence on the modern resolution of the disputes. after 20, 30 years, its applicability has increased manifestly. But the courts always tend upon to look into the alternate redressal mechanism for resolution of the dispute. So, unlike a case where after the law schools you straight away start the practice, now you have various avocations to practice on the specialized field like the maritime law, the taxation field, the arbitration field, which it was unimaginable at least 30 to 35 years ago. Now, as far as the participants are concerned, there are 4 points which I would like to share with you. Not the participants who have come in the final rounds, but also the participants who have engaged themselves in these intense competition. As far as a student of law is concerned, first try to develop a sense of humility, because the fact that you become more humble will take you a long way forward. Secondly, the most crucial aspects which you must cultivate is on the question of integrity. The law is certainly based on trust between the court and the lawyer, and also between the client and the counsel who appears for him. Third, you try to embrace adaptability. Adaptability in the sense, because of the technological advent, where you go more technological in all fields. The law is trying to slowly embrace the technology into its fold. You have various softwares. You have the invention of artificial intelligence. You have seen many instances where the artificial intelligence erodes into the human touch, which are being given by the judges as well as by the lawyers. So, therefore, as a student of law, you must always try to take into fold these technological improvements and try to build up the success. And lastly, try to remember the broader purpose of the law. While the competition like this, try to focus on your upcoming. Certainly, this field is totally different once you go out of the law schools. The practice where you tend to start before the civil court or before the high courts will be completely different, unlike what you have been presented before the courts, or what you have been presented before the moot court competitions, or what you have seen today. Now, at the end of the day, only one team will succeed. It doesn't matter whether you succeed today or you come second in this competition. It will always be a stepping stone for success in future. Wish you all the best in future, and hope that you continue to aspire to grow hard in future. Thank you. Jai Hind.
Thank you, sir, for your invaluable words.
We now arrive at the moment that the competitive spirit of this entire voyage has been building towards: the announcement of results and the distribution of prizes.
We begin with the award for the best memorial. The memorial is the foundation upon which every oral argument is built. It reflects not only legal acumen, but the discipline of structure, the rigor of research, and the clarity of written advocacy. We invite Manisha Tiwari ma'am to announce the winner of the best memorial and request all our judges to present the winner with the award.
Hello. So the best memorial, Carnegie Jindal Global Law School.
Congratulations to the winners. Thank you so much, ma'am. We now move to the award for the best speaker. In a competition that tests the very limits of oral advocacy, this recognition is reserved for the individual whose command of argument, composure under questioning, and presence before the tribunal stood apart. We invite Captain Sushil Shankar sir to present the award for best speaker and request all our judges to present the winner with the award.
I'm pleased to announce the best speaker, that is Hana Mishra, National Law University, Jodhpur.
So the certificate.
And now, the moment we've all been waiting for. Through the preliminary rounds, the quarterfinals, the semi-finals, and now the grand finale, one team has charted its course with unwavering conviction and emerged at the end of this long voyage with the ultimate prize. Now, I would like to invite Justice Ishwaran sir to announce the winners of the 7th MK Nambyar Memorial NIMLAC 2026.
Any guess? Prize goes to Jindal Global Law School.
Congratulations to the winners. Every journey to the final round demands a measure of resilience that only those who have competed will fully understand. The team that receives this recognition has fought through every round with distinction and earned its place on the stage. We invite Joy Tuttle sir to announce the runners-up of the 7th MK Nambyar Memorial NIMLAC 2026.
Indeed, my great pleasure and privilege to announce the runner-up, that is Bengal Merchant National University, Jodhpur.
Congratulations to the runners-up. I now request Ruchir Goenka sir to present the check to the winners and the runners-up.
I just take this with me. You guys don't want the money?
Forgot the main thing.
Don't deposit it, my bounce.
Come on, guys.
A heartfelt congratulations to all the prize recipients. Your achievements here are well earned and richly deserved.
No competition of this stature is complete without the wisdom and discernment of its adjudicators. The grand finale of NIMLAC 2026 was presided over by a panel of remarkable distinction, and we are grateful that each member of the tribunal has agreed to share a few words with us this evening. But before that, we would like to felicitate the audible judges with mementos to express our boundless gratitude. I would like to invite our faculty coordinator, Dr. Sandeep Emin, to present Justice Ishwaran sir with our token of gratitude. Thank you, sir. Now we would like to request our faculty coordinator, Dr. Sandeep Emin, to present Mr. Joy Tuttle, sir, with a memento. Thank you so much, sir. We'd again like to invite our faculty coordinator to present our esteemed judge, Captain Sushil Shankar, sir, with another memento.
I request Sandeep sir to present Manisha Tiwari ma'am with a token of our gratitude. And one last time, I request Sandeep sir to present Ruchir Goenka sir with a token of gratitude. Thank you, sir. I would like to invite our esteemed judge, Mr. Joy Tuttle sir, to share his reflections with us.
A cute little girl was praying to God. Oh God, let the capital of China be Moscow. God, I pray you, I beg you, let the capital of China be Moscow. A priest who was sitting next to the cute little girl got shocked.
hey, cute little girl, what are you praying to God? Don't you know it is even impossible to God to change the capital of China to Moscow? This cute little girl very innocently replied, nothing like that, Father. Today we had an exam, and by mistake I wrote capital of China is Moscow. Therefore I have no other option than to pray to God to change the capital of China as Moscow. This great evening, I'm stepping into the shoes of this cute little girl and trying to address about the winners and congratulating the winners of the competition, International Moot Court competition. Honorable Mr. Justice Ishwaran, other dignitaries, my friends on the dais, off the dais, my dear friends, and Captain Alapat, and better half of Captain Shankar, my dear friends. Moot court competition each and every day is a lesson. It's a passion for me to be a judge, because actually we are actually going back to 30 years old and addressing your queries and questions to grill you, to ask questions. We are actually preparing ourselves. It's a knowledge sharing process when you sit as a judge over here. And indeed, we gain a lot of knowledge. And indeed, there is a lot of knowledge sharing. And of course, there are a lot of content that we absorb out of it. Just one advice which I wanted to pass on, in future. See, the moot court competition, the problems are being, prepared based on the fictions. I mean, of course, we do create a story, for the problems. But your caliber is, you should not confine to those aspects and come out of the sphere and take defenses out of it on the practical knowledge. For example, today, nobody argued about the execution of an arbitration award, no matter whether it's an emergency arbitration award or not, whether the directions issued by the arbitral tribunal is directly enforceable or not, which is a debate which is happening across the globe. In fact, recently in 2025, even the UK also tried the level best to implement the arbitral award, direct enforcement of arbitral award, but finally they got failed in the parliament because it doesn't make sense to the enforcement of an arbitral award. It has to mandatorily go to the execution court and get it done. So according to my personal view, arbitration awards has to be directly executed, not in all the cases, of course, but at least we should give a certain parameters which needs to be defined and restructured wherein arbitration award needs to be executed. So those areas, though it is not the part of the problems, you should come out of the sphere and try to argue the same. I take this opportunity to congratulate the winners and the runner-up and all the awardees, and congratulations, wish you all the best, and God bless you. Thank you so much.
Thank you so much, sir, for your wonderful words. We now invite our esteemed judge, Captain Sushil Shankar, sir, to share his words with us.
Miss Leena Matthews, she's not here. Justice Ishwaran, my fellow panelists, Mr. Sandeep Menon, all you lovely young people over here, very good evening. And I cannot tell you how delighted I'm here to be here today. I did not have the luxury or the opportunity or the good fortune to be in a national law university. When I went to law school, it was a very ordinary law school. You would have never heard that name also. And it was at a late stage of my life, late stage of my career. So when I was asked to come here and judge this moot court competition, I had very high expectations. And I'm happy to say that you all did not disappoint. What a fantastic performance, all of you. And I mean it, all of you. As far as I'm concerned, there are no winners and losers. You all are winners only. Fantastic performance. And if at all I have to give you any, I mean, you all know You're all intelligent people. You will all do well in life, I'm sure. If at all I can guide you, give you some advice, it would be this. Maritime law, maritime arbitration is a very kind of a niche area. It's unique in its own ways. If you take banking, the law and the practice are very similar. Here, it is not that similar. What I'm trying to say is that everybody knows the law. Both the sides know the law. The arbitrator knows the law. So what is it if you, but at the end of the day, it's an adversarial process. There has to be a winner, there has to be a loser. So what is it that is going to give you an edge over the other side? If you stick to only the law, you don't have that edge. So you look for, and I'm not saying this because I wear both hats. I'm also a lawyer and an arbitrator, but I'm also a former seafarer. But that gives me an edge, and I would like you also to, you don't have to be a seafarer to get that edge. Try and absorb the actual practices that happen. Because this is one kind of, like when we use so many technical terms here, vent flaps and this and that. You should, if you know what you're actually talking about, it will give you an edge. And the way you can do that is not from textbooks. You will have to actually meet people. You will have to interact with people, those who are knowledgeable in these areas. And those of you who are in Cochin, you're in a very well placed area, because there are so many people who can guide you. In fact, in this room itself, we have this Captain Alapat who's here. He's a seafarer, he's a pilot, and he's also an administrator. So, you have people like that you can tap. We have Captain Haridas also over there, who is a liquefied gas expert. And I'm sure these people will, if you just talk to them, they will be happy to share their knowledge with you. And this is what will give you an edge when you actually are, competing again with, and I'm not talking about moot court, I'm talking in real life. Tomorrow when you are actually practicing before an arbitrator, this will give you an edge. And it will be appreciated. And I would like to just conclude by thanking this university for calling me. I deem it a very great honor to be here, to have been called as a judge. And I must thank the lovely team, Bliss and his team. They have done such a fantastic job, I'm telling you. Small little things that they took care of. In fact, I was telling my wife, I said, if they decide not to be lawyers, they will be very good event managers. They have it in them. They've thought about just about everything, and I thank you, and I wish you all the very best. Thank you.
Thank you, sir, for sharing your thoughts with us. We extend our deepest gratitude to each member of the tribunal for the time, the rigor, and the generosity with which they engaged with this competition. As we draw the ceremony and this competition to a close, we call upon Ms. Alina Sujit, Secretary of the NUALS Moot Court Society, to deliver the vote of thanks.
Due to the paucity of time, I would not be taking too long, just 2 minutes of your time. So it was in my second year that an email came where there was an expression of interest call for research assistance to the drafting panel of NIMLAC. And at that time, I gave an expression of interest, thinking that it could just be an addition to my CV line. But little did I know it would take up almost 2 to 3 years of my next year life, wanting to probably get into the society year after the year. And NIMLAC just did not become a competition after that. It became a mission to somehow make it happen. And in that instance, there are people who stood through, who shared the same dream. Sandeep sir, we kept proposals year after the year, got rejected, tried again. You are truly the captain of our ship, and this ship could not have sailed without you. The tribunal we have today, the most experienced people we could get from the bench, the bar, and the sea. It isn't weekend, we understand, but still spending almost more than half of your day in a room with students. Thank you so much for your time to everyone. and the participants. You've argued in front of one of the most experienced maritime arbitration experts, and we truly believe that you had a rigorous process. It was a lot of grilling, but I think that is how all the process goes. And you take back what NIMLAC has to offer you, and we hope you spread the word regarding the same. And my team, the MCS, the organizing committee, there is nothing short that I can probably sum up in 1 to 2 words. Probably this is one day event that you see today, but it has been tireless nights prior to this online rounds conduction, led by the judges committee, ideation committee. We've got judges from around the globe who had presided for our online rounds. Even the ideation team, if you open those hampers, you'll see small fridge magnets that's been sat and hand-drawn by the people of the ideation committee till 2 o'clock yesterday in the night. The design committee has not left a shade of blue untouched. All of our brochures and presentations or anything that you see has an element of uniqueness to it. And I know Varsha and Nakshatra has spent tireless days and nights over perfecting each design. Participant committee, you might have received the boarding passes and all the unique emails that you've got. It's all been curated with a lot of thought. The tech committee, the media committee, you might have seen the announcement videos, the trailers. All of those were hours of effort to bring back something that we thought is deserving to be brought back, and that has been NIMLAC for us. It has been an emotion, and I cannot go without mentioning the proposition drafting committee. It was not easy to draft a 74-long proposition. Anushka, I'm not sure if she's here, Aravind, Maheshwar, Jino, Anita, Mahati. There was a lot of alumni that was involved in this process. We all shared a dream to make this event happen, and I am truly glad that this ship sailed this year. And that's us as an organizing committee of NIMLAC after 7 years. Signing off, Secretary Alina Sujit. Thank you so much. Judges committees list, Arbitration Jain, Adishka is not here, Tarun, that's a judges committee. Then we have the participant committee, that is Gauri, Sri Hamsini and David. Ideation is Ron Shah, Haripriya, Ustad. They are not here? They are not here. Ustad. Then design committee.
Thank you so much, Alina. It was beautiful. The ancient Greeks had a word, nostos, for the journey home. It is a root of nostalgia, but its original meaning was simpler and a lot more profound. It meant the return voyage, the passage back after the trial was over. Homer's Odyssey is not about the war at Troy. It is about what comes after, the long sail home, and the person you have become by the time you reach the shore. Ladies and gentlemen, every voyage must eventually find its harbor. Tonight, the 7th MK Nambyar Memorial NUALS International Maritime Law Arbitration Competition reaches the end of its own.
To every team that participated, whether you advanced to the final round or left the competition in the preliminaries, know that this experience has sharpened you in ways that will reveal themselves long after NIMLAC has concluded.
So, on behalf of the Moot Court Society of the National University of Advanced Legal Studies, we declare the 7th MK Nambyar Memorial NUALS International Maritime Law Arbitration Competition, NIMLAC 2026, concluded. Fair winds and following seas to all. Thank you and good evening.